Welcome to the Appellate Division, First Department. We have some 7 hours of argument scheduled for today, so I ask that you please keep that in mind as you request your time and ask only for the amount of time that you absolutely need to make your point. We have your briefs, we have the records, we're fully familiar with the facts of the case. So please keep that in mind. People versus Jose Rodriguez.
Good afternoon, Your Honor.
Afternoon. 6, 3, and 6. Lamb Platt versus Golden Pearl.
6 and 3 for the appellate. 6 for respondent.
I'll give you 5, 1, 5, and 5. Juliana R. versus Abajulu N. Excuse me?
With the appellate, 8 and 2, please.
5, 2, and 5. Rios versus City of New York. Submitted. Kiamov versus the City of New York.
Good afternoon. Plaintiff appellant request 5 and 1, please. Respondent request 5
5,
and 1.
1, and 5. Thank you. Gulick versus Beckett.
For the appellant, 5 and 1.
5, 1, and 5. People versus Chauncey Swinton. Submitted. Meduse versus Plaza Construction.
The appellant, 5 and 1. Respondent
5, 1, and 5. 303 West 122 versus Morton.
For the appellant, 5 and 1.
5, 1, and 5. Atlas MF versus Macquarie, Texas.
Good afternoon, Your Honor. For the plaintiff appellant, 8 and 2. And for the respondent.
6, 2, and 7. People versus Levon Jackson.
The appellant, 5 and 1.
5, 1, and 5. Coleman versus Annucci. Five, 1, and 5. Perez versus Garden Property. Perez versus Garden Property. It doesn't appear that you have an opposing counsel. Do you wish to submit? No, I think we're okay. Submission, thank you. Board of Managers, Latitude versus 3585 owners.
Good afternoon, Your Honor. For the appellant, 8 and 2, please. Good afternoon, Your Honor. For respondent,
7,
7.
2, and 7. Roywald versus Dormitory Authority. 5, 1, and 5. Barrett versus Russ. 5, 2, and 5. People versus Taekwon Camiso. Submitted. Legal Servicing versus Lewis. Submitted. Dash Devs versus Capital Markets. Submitted. First case for argument is People versus Jose Rodriguez.
May I, Your Honor?
Yes, please.
Good afternoon. Thank you. May it please the court, Ben Schatz, Center for Appellate Litigation, for Mr. Jose Rodriguez. The first case on the calendar this afternoon is truly a unique one.
So
Following his,
we are familiar with the facts, and I want to ask you, was your client responsible for any of the delay here?
he's not responsible for any of the delay. The person who is responsible for the delay is his lawyer, who was appointed to represent Mr. Rodriguez's constitutional interests and simply didn't do so. Mr. Rodriguez did everything he was supposed to do. He filed a notice of appeal. He filed his poor person's application. And this court, in due course, appointed him a lawyer who didn't do his job.
But over the years, couldn't he have made more efforts? Because obviously at times he did make more efforts to pursue what was going on with the appeal or the lack thereof.
In some cases, that can be the rule. In this case, it can't be the rule, Your Honor. The people point to the Perez case, in which the client there, the defendant there, knew who his counsel was. He had retained counsel, and he knew exactly what was happening. He was notified of the court of his counsel's deficient performance, and he still sat there and did nothing. In this case, Mr. Rodriguez is literally a mental patient. He's in psychiatric care. He does not speak English, hardly at all. He's an immigrant from Cuba who's been here from less than 2 years. He doesn't have the means or the wherewithal or the privilege to find out who his lawyer, who has never communicated with him at all in the first place, find out what's going on in his case. He doesn't know anything about the appeals process. He doesn't know there is an appellate division as far as we know. And so the answer is no. He's not required to reach out and make inquiries about the status of appeal. That really turns the whole idea of effective assistance of counsel on its head. It's not this disenfranchised individual's obligation to keep tabs on what his lawyer is doing. It's the lawyer's job to make sure that Mr. Rodriguez's rights are protected, and he didn't do that. He dropped the ball, and this is a case where the court needs to acknowledge the mistake and grant the relief we're requesting, and it's really the only relief that approximates justice in a case like this, which is dismissal of the charges. If there are no further questions, I'll get up on rebuttal again. Thank you.
Thank you.
May it please the court, Milan Chachanda for the people.
So, counsel, we heard that at least your opposing counsel feels it's not the defendant's fault. He's not responsible for any of the delay. There was an awful lot of delay here. And I want to ask you, how can the defendant now at this point raise a meaningful appeal where significant portions of the record are missing, the jury selection is gone, there's no evidence or record of the 7:30 argument and what well, we know the result didn't happen, but the argument. So it seems reconstruction is impossible. How would he not be biased in this case? How are his constitutional rights not affected here?
Well, Your Honor, it's because he's responsible for the majority of the delay.
What
He had
about the delay when your office was contacted and they said, oh, sure, this case was appealed. In fact, the case is People versus Perez. And it was not this Perez. I mean, did that count for any of the delay?
Your Honor, that was 32 years after he was assigned counsel. So at that point, he let the appeal languish for 32 years.
But counsel, you heard what your adversary said, that the defendant is mentally ill. Under such circumstances, is it really his obligation to pursue, to see what happened, given the fact that he's an immigrant, Spanish-speaking, came to the country and pretty quickly thereafter ended up behind bars?
Your Honor, I need to point out that it is at this juncture that my adversary is conceding that defendant filed a pro se motion for assignment of counsel in poor person's relief.
He did. He did.
He did.
But in the beginning, He was, his counsel never got in touch with him, and that counsel was disbarred for that very issue, not following up with clients on cases and anything else. It didn't happen immediately, but for the same, he was never contacted. And he said that he wasn't contacted because, well, I'm sorry, he said that the attorney contacted him in the beginning and said that I'll let you know if we win.
Your Honor, this explanation at this belated juncture by defendant is actually the end of an evolving set of explanations he's given. His first explanation was that his counsel never even filed a notice of appeal, and then he...
That's not untrue, right?
I'm sorry, and that's not true.
That's not untrue. He didn't. The counsel did not file a notice of appeal for him, did
Counsel
he?
did file a
Oh,
notice.
he did file a notice of
Yes,
appeal. Okay.
absolutely. And that's after that he filed
Right.
a pro se motion for poor person's relief. So he starts off in 2014, 32 years later, saying, you know, nothing's been done with my appeal. I've never had a notice of appeal filed. And then when confronted with the fact that he has had a notice of appeal and he moved for poor persons himself, then he lands on a hypothetical like, oh, well, maybe for all that is known, I could have maybe been under the impression that I was supposed to wait. And then 3 years later, then he says, oh, okay, I did tell someone in 2014 that nothing was done on my appeal. So his explanations have been evolving. He had the wherewithal. And, Your Honor, I do want to point to the Perez case by the Court of Appeals that says even if let's say, even if he hadn't filed a pro se motion, he had 32 years to learn or get over the impediments he says that he has in terms of learning English. First of all, he did file a pro se motion, but his explanations have been evolving, they've been shifting, and there's case law that says, yes, we do not deny that his counsel did not perfect the appeal, but in all of the cases defendant has cited in his brief claiming due process violations, there have been a range of efforts by a defendant, including consistently writing to the court, seeking something from counsel. Here, defendant just stayed put. He didn't seek to have his appeal expedited, seek to contact counsel, seek to ask this court what was going on with his appeal. In all of these due process cases, there have been concerted efforts by the defendant, and they've been thwarted along the way.
Counsel, I want to address the fact that it appears that a fellow inmate seemed to corroborate the story about the defendant being unaware of the situation and asked that inmate to assist him with the quorum nobis application. And it was the fellow inmate who suspected that the appeal was never perfected. So can you address that? Because once that happened, it seems as if the defendant then diligently pursued the appeal.
Your Honor, this is, again, it's 32 years after he says he contacted he spoke with this inmate. And again, Your Honor, the inmate's affidavit is based on self-serving declarations by defendant who, again, 5 years later said that the notice of appeal hadn't even been filed. So again, his explanations have been shifting, and that on its face should signal that they're incredible. And then when you consider the circumstances surrounding, let's even to say if he thought that his appeal were affirmed, he spent 32 years without moving for collateral relief, like the inmate he's talking about in a quorum nobis petition or any other kind of collateral relief. And again, this affirmation by a fellow inmate is based on a self-serving and evolving set of explanations by defendant. An appeal, of course, the defendant has the right to appeal, but it must be timely exercised and asserted. And here, over 3 decades of inaction and the evolving explanations for that inaction just undermines any claim that he makes right now of his lack of knowledge or his lack of wherewithal.
So what about the fact that the people had opposed parole and knew that the appeal was pending and you did nothing? Can you address that?
Your Honor, this court has held in Williams, which is cited in our brief, on page 36, the people are under no obligation to advance a sentence defendant's appeal. And that makes entire sense. We are on a position, we're taking the position, obviously, that the conviction was legally obtained and is a solid conviction. We are no obligation to advance a sentence defendant's appeal, especially when he has shown no inclination to exercise or formally take action with respect to that appeal. It's not our burden, it's defendant's burden. He has that right, but he has to exercise it diligently, timely, and show that he cares to, protect his rights.
Thank you.
He did not do so here. Thank you, Your Honors.
Just a few brief
Counsel,
points.
Counsel, before
Yes.
you begin, it appears that your adversary is highlighting the fact that the defendant's actions should outweigh the ineffectiveness of the counsel that he was assigned, whereas that didn't, because he didn't pursue anything, that it doesn't really affect his due process, as in that we shouldn't really give that much weight to the egregious ineffectiveness of the counsel here. How should we address that?
I don't know how you can say that. This is a whole system put in place to protect people exactly like Mr. Rodriguez. And for the people to say that Mr. Rodriguez is entirely to blame on these facts, it's hard to imagine a more vulnerable criminal defendant than Mr. Rodriguez. And for them to say that it was his strategic decision for some reason to wait until the vast bulk of his sentence had been served before making a point to raise it with the court makes absolutely no sense. Mr. Rodriguez suffered the consequences of this delay more than anyone else. There was no strategic benefit for him to wait that long. This point about him saying there's a notice of appeal and then saying the notice of appeal wasn't filed and then it was, it's because he's totally in the dark. He has no idea what's going on. He's sitting up there in a box at the Canadian border, and just by the grace of God, there's a jailhouse lawyer who says, I've got to look into this and see what's going on. And if that weren't the case, we wouldn't be here now. Fortunately, we are, and there's a chance for the court to do something here. And I'll just add one more point, which is that this court has already considered all of the arguments that my adversary is raising about who's to blame. They made a motion to dismiss. The motion to dismiss was denied. There was no invitation from the court, as it normally does, to allow them to renew the motion after full briefing. In cases like this, when a motion's denied, and it was denied by a 4-justice panel, in that panel's discretion, that's the law of the case. And the law of the case here is that the motion arguing that Mr. Rodriguez is to blame is of no merit. Thank you.
Thank you. Thank you both. Lamb Platt versus Golden Pearl.
Good afternoon.
Good afternoon.
May it please the court, my name is James Rowland. I represent the appellant, Plaintiff Lamb Platt, in this matter. As Your Honor said earlier, I know you've read the briefs. So,
Yes, so I'll just ask you then a question,
Sure.
beginning. Yeah, there is a contract in this case, and you are seeking damages that are equitable in nature as well. Well, aren't you, and you're seeking consequential damages here, aren't those damages prohibited by this contract?
I think there are certain damages that are limited by the contract, and they're expressly identified in the contract. The contract says the consequential damages includes, and then it defines what was there.
Counselor, I'm sorry. Does that, the word include, does it somehow limit the scope of the clause?
I believe it does, Your Honor, and I believe this. I'm sorry.
Isn't that just an example of the kinds of things that are excluded?
I don't believe so, Your Honor. I believe in this case because later in the contract they referred to all consequential damages. This was meant to limit the consequential damages. As the Court of Appeals held in Red Hook, which is quoted in counsel's papers and in my reply papers, the word including or includes can limit as well. And it's our position, that's what was done here. The parties negotiated and executed an agreement. Later on in the agreement, they clearly say, they use the word all. There's no without limitation. All the cases cited by counsel where he says includes just expands on the definition, all had other terms such as without limitation or all consequential damages. In this case, the parties negotiated a contract. They defined, it says includes, and defined what they were agreeing to waive.
Wait, counsel, unless maybe I'm mistaken, but I think it does say this mutual waiver is applicable without limitation to all consequential damages, etc.
Yes, that's that's solely in connection with the termination for cause, Your Honor. If you look, it says it in accordance with Article 14. There's two different sections here. There's the top section which talks about what was waived, and then there's a lower section that says in the case of a termination for cause, which is in dispute in this case, then it's all. But all is not used above, Your Honor. I mean, the parties negotiated. Just it's not often I get to use Latin, but as the court held, sorry, Your Honor.
Can you address the other issues with respect to restitution that was raised by my colleague with respect to equitable remedies that you're seeking here?
It's under a breach of contract claim. We're claiming that these.
But you're not claiming any kind of equitable relief, correct?
We didn't claim equitable relief, and that one of the issues on the
But
appeal
aren't you looking for disgorgement here?
Sorry?
Aren't you looking for all the monies back?
We believe they're direct damages. We paid them the money to do something, they didn't do it. We believe those are direct damages. That's what's
But
alleged
that's
in the complaint,
forfeiture.
Your Honor.
You're essentially asking for all the monies back. Isn't that disgorgement or forfeiture, that kind of thing?
I believe it can also be a direct damage, which is an issue that gets determined factually. This court in the Court of Appeals in Biotronic said that sometimes lost profits could even be not consequential damages or not. It's issues we've claimed in our complaint that these are direct damages. The court, on a motion to dismiss, is supposed to take those allegations as true, unless they're refuted by documentary evidence. There's no documentary evidence that refutes that. If ultimately it's determined that we're not entitled to that, or that's not a direct damage, when facts come out, that's fine, Your Honor. But this was a 3211 motion to dismiss, and there was no claim for disgorgement. And counsel, at least in my discussion with them, have taken the position now that we're not entitled to those damages. We've alleged them as direct damages. The complaint was verified. I mean, I believe that we're entitled to at least pursue those claims. I don't think they should have been dismissed on a 3211 motion because we didn't allege disgorgement as a cause of action.
Well, the
because
fact
we
that
have a breach of contract.
The fact that you characterize your damages in a particular way, we're not bound by that, right? I mean, can't we look to see precisely what you're seeking here? And what you're seeking here.
The characterization of damages in a complaint, I believe that if we're alleging these are direct damages, then yes, the court, when interpreting the complaint in the 3211 motion, and with the case law saying that direct damages and consequential damages and other damages determination are fact-specific, they shouldn't be decided by a 3211 motion. I think that there was no disgorgement claim. We've alleged them as direct damages, and we're entitled to at least seek recovery of them, and they shouldn't have been dismissed as a 3211 motion. Now, Your Honor, just briefly, because my time's running out.
Why don't you finish up on rebuttal? You do have rebuttal.
I'm sorry?
Why don't you finish up on rebuttal?
Sure. One of the issues, as the courts realized in this, is we were...
On rebuttal, I said.
Sorry?
I said on
On
rebuttal.
rebuttal. Sorry,
Sorry.
Sorry about that.
Okay.
May it please the court, Robert Howard on behalf of the respondent, Golden Pearl Construction. Two key points. This is a broad waiver of consequential damages. I think the cases are clear that when there's a broad waiver and then there's the word including followed by specific items, those specific items are indeed examples.
But generally, your adversary's point's well taken. Usually, what I've seen at least is including but not limited to language, which is a little more precise than what you have here, correct?
A little more precise, but the cases that we cited in the brief have, as far as I've seen, universally held that it's redundant language. Plus, if there's any doubt, the court has already noted the mutual waiver at the end of the paragraph 8.0. It says, including without limitation, all consequential damages due to either party's termination for cause in accordance with Article 14.
But but I think your adversary's point is that when the parties know when to use that kind of language, they put it in there. Therefore, the other provision cited to is not as broad as you purport to say it is.
There was this case at oral argument below. There was no dispute that this was a termination for cause, and that Article 14 does apply. And I don't think that there's any cases that I've seen where the omission of without limitation signifies an intent to limit the specific examples. I think that the clause here, without limitation, makes it abundantly clear, and that a commercially reasonable interpretation of this clause is that all consequential damages were intended to be waived without exception. And also, I would point out that, if there was any doubt, the language in paragraph 1 for rental expense is the price of using something over time. And the interest that is the subject of this, which really is dicta, this finance expense, is really rental expense of money, because interest is the use of someone else's money over time. I don't think there's any doubt that the parties intended to waive all consequential damages, and the specifically enumerated items were not intended to be a limitation. But I would also note that what this whole case is about, this whole appeal, is this dicta that the court cited about finance damages. And for whatever reason, the court did not include that language, finance damages, in the final order. The court just dismissed all consequential damages. So I don't think that provision in dicta is appealable. I think that the language based on the court relied on the broad language of Article 8.0. It says all consequential damages are waived, and the specific limitations are really superfluous in my view. With respect to the equitable claim is clearly governed by a contract and clearly barred.
But your adversary says that there is no equitable claim, that they're alleging direct damages, and that we are bound to accept as true for the purpose of the procedural aspects, procedural stage at this stage, that representation.
What the complaint says is they want disgorgement of a $2.7 million contract payment. That's restitution, and as last time I checked, that's an equitable claim, and that claim is barred by the contract. With respect to direct damages, bear in mind, we made no motion below to dismiss any specific categories of quote-unquote direct damages. We only moved to dismiss the consequential damages. If there are direct damages, there is a specific provision in this contract in Article 14 upon a termination for clause, which identifies specifically what the quote-unquote direct damages are by agreement. They're liquidated. That's an issue, though, that's not before this court. There's no provision in the order that says that certain direct damages are out or certain direct damages are in. That's an issue to be decided when we get closer to trial. All we have is an order here that says consequential damages are dismissed under a broad provision. There's a provision that says lost profits are dismissed. What's one of the specifically enumerated categories is the lost profits. And finally, the equitable claim. The equitable claim to disgorge, I don't care what counsel characterizes it, a claim for disgorgement is an equitable claim, and that claim can't survive in light of a contract. Could there be a $2.7 million disgorgement claim as direct damages? That issue is not before this court. I would argue when we get there that there's a specific contract provision, Article 14, that defines what those damages are, but that issue is not before this court on this appeal. And therefore, we submit that the order should be affirmed as it's written.
Thank you.
Thank you.
May it please the court, Joanne Bonacci on behalf of the dismissed defendants, Kenneth Caleo, Harry Gross, Stephen Caleo, and CNY Group, LLC. Our portion of the appeal, Your Honor, is just a discrete issue. When the appellant filed the appeal in the case information statement, he was appealing our complete dismissal in its entirety. When the brief was filed for perfection, at that point in time, he was no longer dealing with our issue, and so therefore, in an abundance of caution, we filed our respondent's brief simply to advise the court of that issue and that the appellant had waived any right to proceed on appeal from the court's first order dismissing our defendants.
Do you have anything else?
No, that's it.
Okay, all right, thank you.
Hi. Just on the last point, Your Honor.
Yes.
As we argued in our papers, we were directly told by the trial judge that because there's a motion to amend the complaint, an amended complaint that was filed that dealt with the allegations that there wasn't sufficient specificity with the claims against the individual defendants. The trial judge told us we had to appeal those portions of her decision which were final. She was going to grant the motion to amend, and she would determine whether the amended claims against the individuals were specific enough, but that's why we're here on these sole issues. As far as the language, counsel keeps on referring to it as a broad limitation of a broad waiver of consequential damages.
Probably because it says all before consequential.
It says all in connection with one specific section. It doesn't say all where it defines where it's supposed to be. And the cases that counsel
And then
cites,
including, but go ahead.
it says include, Your Honor. It doesn't say including, and words are important.
Oh, yes, they are.
As the judge indicated, we always use things including without limitation. The cases they cite in their papers.
We don't always, but that would have provided a bit more clarity.
Yes, Your Honor. Just one last thing. The cases cited by counsel, and we cite them in our reply papers, that he says say that includes is just expanding on what's there. All of them had language like without limitation or all consequential damages. None of them had just the word includes here, and none of them had a later provision where it did say all. The parties negotiated and agreed to their limitation, a waiver of consequential damages, just to what they defined in the contract.
Thank you all. Juliana versus Ovladjulu. Counsel, you should.
May it please the court, Jeffrey Birkenberg for the appellant. Your Honor, this case raises a public policy issue, whether a person can take out a gun, rob a bank, take the proceeds, and then be subjected to paying child support based on the theft that he just made. Obviously, he can't. What happened in this case, one fact is agreed upon between the trial court, the respondent, and the appellant. The funds were illegally obtained. This individual took money that didn't belong to him, kept it, and forfeited it. He served time. He was convicted and incarcerated. In fact, during the trial, an order had to be issued to produce him to testify. It's clearly against public policy. The Court of Appeals has said in K against K that child support funds must be based on honest efforts. Years later, this court, citing K, made the same statement, quoting the same words.
Yes, I don't know that your client should be rewarded for hiding income or committing those crimes, but it does appear that the child support may not have been fully developed.
That's a certainty. That's a certainty. Not only that, Your Honor, counsel and the lower court both took the position that because he was incarcerated as a result of his own misconduct, and justly and lawfully incarcerated, that he shouldn't benefit from that. But that doesn't mean you take money that he doesn't have and which has been forfeited to the government and base it for child support and base it also as a landmark for future child support. The Moore case, which I cited in my initial brief, comes from Pennsylvania, but it's very instructive. It talks about the public policy considerations in doing such a thing. It talks about the fact that it really creates a perception in the public that the law enforcement is inept and
Counsel,
cannot.
did your client produce tax returns as some indicia where courts could make a determination of what, in fact, what income he was generating?
This was a trial de novo. Both parties produced tax returns in the initial trial, and at the outset of this trial, the judge said to counsel, "Do you want the exhibits back? I have them." They were there in the courtroom the whole time. I cited in my reply brief that the court had the right to take judicial notice sua sponte or on the application of either
Why
party.
didn't you introduce them at trial, at this particular hearing?
Oh, that was clear because he was in a position where he would have to show, before he realized that what was subpoenaed was going to be produced, that his tax returns differed from his income reported on his corporate deposits. But that income is still illegal. That income is still unlawful. You can't base child support on it. It's a public policy concern. Not only that, the judge went over the statutory cap without referring to any of the statutory factors. Although counsel says he does, she doesn't point to one that he did. The only thing she can say is that his income exceeded the amount necessary to go over the cap, but that's alone not a statutory factor because that's required to go over the cap. You can't even look at the discretionary factors until you get there.
And was there any evidence adduced with respect to what the child's needs were, what the child's standard of living was in this case?
There are cases that say you can base support on needs. But here, even the lower court held that both parties' testimony was not believable. Assets were concealed by the respondent. Income was concealed by the respondent. Testimony was contradictory by the respondent. And there was no documentary evidence of any of her expenses for the child. And here, again, undenied in the briefs, was that not only did the child support exceed the cap, but it exceeded the child's needs. And there was an appellate division, 3rd Department case I put in the brief that says that's totally improper. You can't.
Thank you.
Counsel, if you could just start at that point where your colleague adversary left off in terms of the
Just let's
proof.
get a notice of appearance.
Certainly. Good afternoon, Your Honor. Andriana Toscano of Kleiman and Associates for the respondent.
Your question?
The evidence, the proof that was presented as to the child's needs.
Yes, Your Honor, and actually it was through the respondent's financial disclosure affidavit and through her own testimony, which provided that there were significant expenses or expenditures on behalf of the child's needs. And through that, we'd actually requested in summation from the judge and cited—
What were they specifically? What specifically did she testify to or prove as the child's needs?
Certainly. The child had daycare expenses that the respondent's mother was actually providing for her. I believe it was $100 per week. In addition to that, their health insurance, food, clothing, anything to the like with respect to the child. I believe there was also extracurricular activities that the child is getting older these days. So in the respondent's financial disclosure affidavit, it does list all the expenditures that was on behalf of the child's needs, which was subsequently requested of the court in summation and cited with relevant case law at the close of the argument in the trial de novo. Your Honors, a support magistrate is afforded considerable discretion in determining whether to impute income to a parent. This decision can be based on the party's credibility, and the court has great deference to make that assessment with respect to a party's candor and financial transparency with this court. Our position is that the court's determination should not be disturbed. According to the New York—
So I do have to ask you, I'm sorry.
no, it's
My colleague asked about the child's needs, which you said, well, there was a certain amount for that and a certain amount for health care premiums. But what was I think it was $440 per month for the child care expenses and then another $30 biweekly for the health care premiums. But it seemed like those expenses were covered by the statutory award up to the cap. But then there was another amount of about $632.88. what was that? What was the basis for adding that amount?
Your Honor, I believe the basis for adding that additional $600 and change was the fact that the judge, again, the judge did have discretion in awarding support above the cap. And contrary to
But
my,
substantiated by what?
with respect to, it's actually any other factor that the court deems relevant.
But I'm sorry to interrupt you, but doesn't case law hold that the court has to actually consider the child's actual needs in determining child support?
Absolutely, Your Honor. it
So
does.
then, for the amounts above the cap, how is that determined?
Your Honor, Section 413(1)(f) says any other factor that the court deems
But
relevant.
what were those factors, in other words, and how were they substantiated?
They were substantiated. The only thing that the court had was the appellant's lack of candor and testimony, and it is our
Well, I
position.
have to say, I didn't see in the record any candor on the part of the mother of the child. There was some question as to that as well.
I'm sorry, I didn't hear.
I said, at least from the record as I saw it, there seemed to be some credibility issues on the part of the mother of the child as well.
Yes, Your Honor. I do note that, and I acknowledge
And
that.
she would have been the one attesting to the expenses of the child.
I understand that, Your Honor, and that is a significant question and concern to raise. However, the issue regarding the respondent's testimony or the respondent's credibility stems with respect to one piece of parcel of property that was not listed on the financial disclosure affidavit of the respondent.
But again, aren't you focusing on the wrong issue? Isn't the issue the child's actual needs as opposed to what the father had in terms of assets?
Yes, Your Honor, I understand that, but in the court, in Support Magistrate Lopez's decision and order, which is a very detailed 6-page findings, which sets forth the issue that the court had with respect to the appellant's candor and lack of credibility with this court, and that is the factor. Any other factor that is relevant to this court, the fact that he did possess certain funds that qualified as could qualify as imputed income.
Yeah, but that's saying, well, he had $1 million, but even though the child's needs were only $500, we're still going to charge him $500,000. I mean, there has to be, the child's needs have to be, articulated and substantiated. It has to be the actual needs of the child.
I understand that, Your Honor. I do just defer to the papers and also Justice Roberts' decision in order, which also which we believe speaks to that issue as well with respect to the child's, not this child's needs, but with respect to the 413, Section 1F, any other factor that deems relevant. And we do believe that that actually is substantiated therein, and I would defer the rest of the remaining arguments to the respondent's brief, if there aren't any other questions.
Thank you.
Thank you very much.
You're correct, Your Honor. You have to look at the actual needs of the child. When the mother testified to the child care expenses, the lower court disallowed it. Not only did the lower court disallow that testimony because it held the proof inadequate, but she pretended not to remember that her own mother testified that she would, on cross-examination by me, testified she would watch the child for free. And the mother insisted on paying her own mother to watch a child that she requested no payment for and said she would watch for free just to increase the child support needs. That makes no sense, and it shows the true motivation on the mother's testimony. And saying the needs are established by a financial form affidavit created by the witness itself with no backup documentation is circular reasoning. It's the same reasoning counsel used when she took a tax return, showed it to the court, said this is the tax return, and the court takes it into evidence over objection. We don't need rules of evidence. We don't need witnesses. How do you do that? It's impossible. That's not judicial discretion. That's throwing the rule book out the window.
What about section 413 1F of the Family Court Act that counsel cites to referring to any other factors?
Absolutely. The court can use any other factor, but it has to be related to reality, and it has to be related to the actual needs of the child, and it has to be related to the facts in the case. That wasn't done here. The judge's own decision.
And so those
says
credibility factors.
Credibility is certainly a factor, and you can certainly consider imputed income and going other places, but not solely on credibility. I believe it's pages 6 and 7 of the brief, of the reply brief, which listed every single case counsel listed, talking about lack of credibility and imputed income. And in each one of those cases, there was a separate, independent, substantive reason. There has to be. And the only possible reason there can be here would be the illegal income, which is against public policy.
Thank you.
Thank you.
Thank you both. Kiamov versus the City of New York.
Good afternoon, Your Honors. May it
Afternoon.
please the Court, Craig Femister from Napoli-Shkolnik for Plaintiff Appellant. Your Honor, the issue on this appeal is the admissibility of defendants' respondents' self-serving hearsay statements which were contained in an uncertified police report.
I'm sorry, Counselor, who initially submitted that police report?
We did, Your Honor. The plaintiff
Okay,
submitted
so then
it
how
as
can
part
you
of the...
stand here and make that argument when you submit a uncertified report? I understand your argument. It's a little more subtle. It's for a limited purpose. But you submitted it. So haven't you at that point waived the objection by submitting it?
Well, Your Honor, and I think that's the distinction. The reason we submitted it was to just show the points of impact.
But you didn't just limit it to a redacted version of the report and just show that. I mean, you just put in the entire report was appended. So when you put in the entire report, it allows the other party to rely on the entire report.
Well, we understand that, Your Honor. There
Doesn't
are
it?
some
I
cases
mean,
that are... I'm sorry.
I said, doesn't it? I mean, you can address that.
Yeah, well, our position is that it doesn't allow everything in the report to come in. It allows any reference or argument made as to the reason we submitted the report, which was to show the points of impact.
By the way, did you make that clear down below?
I'm sorry?
Did you make that clear down below?
Yes, Your Honor. Well, no, I apologize.
Because you didn't certainly, you had an opportunity to file reply papers, and as I recall from the record, you didn't file reply papers. That would have been a great opportunity to say what you were going to say, or maybe it would have been too late in any event, but you could have done it then, right?
Correct. There were no reply papers filed. I don't have an answer as to why that was not done. We are asking the court, in the interest of justice, the Appellate Division, as Your Honors I'm sure are well aware, has the inherent power to decide issues raised for the first time, and we believe that this is a case where...
Except here, there are conflicting facts. I mean, considering that they have relied on this, there are two different things.
Well,
She says she was there. He says, and I know you've cited to a case where you say, well, if you don't see them, but he said she came out of nowhere, which is a little
Except, Your
different,
Honor.
which is a little different.
I'm sorry to interrupt you.
Yeah, no.
Except, Your Honor, I believe there's a distinction here, and I know you know the facts of the case, but I think it's important to note she had testified or had submitted in her affidavit she was halfway across 34th Street when she was struck. It's impossible she came out of nowhere. She crossed 2 lanes of traffic before she was struck, at least. And that's the point, that his statement in the police report, even if you believe it to be non-hearsay and admissible, it doesn't rise to the level of the burden of proof necessary to counter what plaintiff had submitted.
Okay, but except that she says she had already walked across the street to get to the point of where she was. He says she came out of nowhere, which could suggest she didn't walk across the street, that she was walking in the opposite direction and came off the curb. I mean, he says she came out of nowhere. So, that's how we get to this position of this conflicting testimony.
I understand, Your Honor. There's the cases, however, that are cited are also distinguishable, which I believe we pointed out. And the second department case cited, Pouncey, involves directly contradictory statements related to the color of the traffic light that shouldn't be relied on by this department.
There are 2 individuals. Doesn't the second one say she didn't cross the street or something? Correct me if I'm wrong.
Well, that was not in the police report, Your Honor. That was in I don't believe that was in the police report. I think they had submitted an additional internal report that indicated that, which, again, was not sworn to, was not in affidavit form. Unless there's any other questions, I will rest, Your Honors.
Okay.
Thank you.
You may begin.
Thank you, Your Honor. Jesse Townsend for the respondents. Your Honor, plaintiff's appeal of Supreme Court's order denying the motion for summary judgment should be dismissed because there's no preserved issue for this court to consider. As was already noted in questioning of appellant's counsel, this issue was not raised below in the reply brief or in any other place on the record. And therefore, there's really no issue for the court to consider, and the
Well,
order...
if it's a legal issue, couldn't we consider it?
If your honors were interested in reaching the issue, then you would affirm on the merits because the legal issue would be clear based on this court's case law concerning waiver. Here, though, I don't think you need to reach the issue. Opposing counsel referenced the idea of interest of justice, and I think it's worth remembering the procedural posture we're in. We're not asking for plaintiff's case to be determined against plaintiff. We're simply seeking a jury trial. It was plaintiff that moved for summary judgment early, and we're just seeking denial of that summary judgment or affirmance of the denial of summary judgment so that the parties can go on to a jury trial.
You know, generally, it's been my experience on summary judgment motions that when a party moves through summary judgment and the other side opposes, they usually oppose by affidavit and not in the manner in which you chose or your office chose to handle this, correct?
I understand your point, Justice Singh. And I was not counsel below, so I can't speak to why my office chose to brief it this way. I would point out, Your Honor, though, that it was plaintiff that put in the police report, and plaintiff having put in the police report, I think we were entitled to then point to that police report in our opposition. As I pointed out in my papers, because plaintiff put in the police report in their motion for summary judgment, their motion, not even getting to our opposition, their motion did not meet the prima facie burden of showing a lack of material issue of fact.
Yeah, but their argument is that it was only the uncertified police report was only for a limited purpose, and therefore we shouldn't look beyond that limited purpose to what you are seeking to raise an issue of fact. Correct?
I understand that argument. The fact is that at nowhere in the record before Supreme Court did plaintiff make clear that they were offering it for a limited purpose. They had a particular use for it. That's true of any piece of evidence. Of course, whenever counsel offers evidence, they're hoping to make a particular point. But they don't include limiting language, for example, in the attorney's affirmation that offered that exhibit, nor do they offer just excerpts of the report to just make their particular point, nor do they offer a redacted version. There are certainly ways they could have attempted to make clear that they were offering this for a limited purpose and not a general admission. And plaintiffs didn't do that. So because they failed to do that, they've waived their ability to make this objection now. And that's very clear from this court's case law, St. Cyr v. New York City Transit Authority, which was issued just earlier this year, Supreme Systems, Cruz v. Scarrett. All these cases make the same point, that when a party, a movement, attaches a document to their motion, relies on that paper, they've waived the ability to later object to its admissibility. And once that report is in the record, it's clear that they are directly conflicting accounts contained just within the police report that create the issue that needs to be presented to a jury. Plaintiff says she was in the crosswalk and has crossed the street. The sanitation driver, the defendant, disagrees. He says she appeared out of nowhere, and that she was not in the crosswalk. So just that report by itself makes clear there is an issue of fact, and that plaintiffs didn't meet the prima facie burden, even without considering defendant's opposition. If defendant's opposition is considered, then additional information does come in, including a statement authored by the other sanitation worker who's not a party, but also a witness. And at no point did plaintiffs object to the inclusion of that statement in the opposition to summary judgment. So any objection to that is also waived. Unless there are further questions, we'll rest on our briefs. Thank you, Your Honor.
Thank you.
Just 2 quick points, Your Honor. as counsel made a statement that we didn't have any limiting language in the original motion in paragraph 12. Immediately before we reference Exhibit F, it states, moreover, the fact that defendant struck plaintiff with the front of his vehicle, see Police Accident Report Exhibit F. That's the limiting language. There is a box on the police report that indicates that the front of the impact, that the impact was to the front of the vehicle. That's all that we were referencing in there. So it was argued below in the underlying motion, or at least brought out. Furthermore, the cases cited by defendants, there's the Cruz versus Scarritt case. This is an admission that the defendant made in the police report to doing an illegal U-turn. This is not a self-supporting statement. It's an admission against his own interest. The other case involves deposition testimony, not a police report. Thank you all for your time.
Thank you. Thank you both. Gulick versus Beckett. You may begin.
Thank you, Your Honor. Good afternoon. My name is Corey Shapiro. I represent the defendant, Tom Beckett, in this divorce matter. This is a sad example of what parties who are in same-sex couples had to do to create an economic unit. The lower court below made an error on the first issue by the misapplication of the case they cited, which was CY versus HC. That's a 14-year-old case, which was by Justice Richter. And in that case, although it was a domestic partnership like our case, although they were in a quasi-marital relationship like our case, in that case, they purchased property together.
But here, the property here wasn't purchased together. The property here was purchased by the plaintiff before the plaintiff was in a relationship. And then, before marriage, the plaintiff added the defendant as a joint tenant, correct?
That's right, and that's the difference.
And then did not change it later on. Is that right?
It was just a joint tenancy with right of survivorship. And that's the difference and distinction between that case. In that case, the parties made different contributions to the down payment, and Justice Richter gave back each party's down payment they put in. Here, Justice Dawson gave back 100% of the value of the 2003 value of the apartment. But that transfer, when the proprietary lease was transferred, that was a gift. It was also
I'm sorry, can I stop you there for a second, counsel? What proof supports your contention that plaintiff intended to immediately gift half of the apartment?
The proof, Your Honor, is in the change of the proprietary lease and to put him on the mortgage. It makes no sense that someone would be a future owner, but a current debtor. Their whole relationship.
But wasn't there testimony that the purpose for this arrangement was because this was a same-sex couple, and there was concern that in the event of an early demise, that your client would be deprived maybe of a right. So the whole point was to protect him in the event he died.
Case law for gifts, the motivation for gifts is irrelevant. We look at documents. Everyone in a divorce, especially a high conflict divorce like us, is going to make self-serving statements like that.
So let me just ask you this. When the plaintiff put this as a joint tenant and put it in the mortgage, could he have stated it as a joint tenancy in the entirety?
No, they weren't married, Your Honor. They were constitutionally unable to get married until much later.
But then did he do anything to change it?
No, they kept the status quo. They lived as an economic unit.
Wouldn't that have been the thing to do then?
But you're asking, that's the whole thing. You're asking for, that's the problem, what you're making same-sex couples go through these hoops. I think that's utterly inappropriate.
Well, let me ask you, whether it's a same-sex couple or not, who had the property, and one person had it and put the person as a joint tenant, and then got married, same sex or not, once you're married, it's the same law, and never changed it.
Right, so that
Wouldn't
means
we
he's,
be in the same place?
I think they're owners, Your Honor, once the proprietary lease is changed. On the second point of the first issue of this case, the judge only gave 20% of the appreciation. That's also a mistake because the case cited by the court, again, which was Justice Richter's case, in that case, they gave 50-50. They did that because of the context of the relationship. This is
I just want to make clear you answered my question. Would it be any different if it wasn't a same-sex couple and these same facts were the case, and then they got married, and one party didn't change from a joint tenancy?
I don't think the title is relevant in a marital action for your example, Your Honor. The whole point we have marital property, we have separate property, and marital property titles are relevant. If two parties purchased it by tenants in common, they had the option to put percentages. If they weren't married, the only option they could have done was joint tenancy. That's what they did here. If two heterosexual back in the day bought property as joint tenants, they probably would not have, most couples wouldn't have done the tenants in by entirety, Your Honor.
Did you have anything else? I mean, if you needed a...
Yes, Your Honor. I wanted to just raise one point on the on the appreciation. I want to raise one point on the appreciation. 20% is error because here, the case cited by the court was 50-50, and it's very similar facts. There was no expectation of reimbursement by the plaintiff. That's what he testified to. There was no accounting. There was no demand. Why? This is a personal romantic relationship. This is not a commercial transaction. This is a personal romantic relationship. And the last thing the plaintiff did when he closed a joint account, which was used to pay for all of the expenses on the property, all of their lifestyle, which he made the greater contributions. And the case cited by the court by Justice Richter, in that case, one party made all the greater contributions. In that case, he divided the account equally after paying the mortgage. That shows intent, and that's what we want. On the abuse of process issue, just very briefly, you can't find someone abused process in a divorce action that never started. And that's our point. It might have been some other tort, but it couldn't be abuse of process and nothing else is pled.
Thank you.
Thank you.
Oh, I'm sorry. Go ahead.
Good afternoon. Daniel Mark Lipschutz of Aronson, Mayevsky, and Sloan for the respondent, Dr. Roy Gulick. May it please the court. We ask that the panel affirm the lower court's decision on both issues, both with respect to the issue of partition and with respect to the issue of abuse of process. I think the questions that the panel posed to Mr. Shapiro were spot on.
Well, I'll ask you a question. Mr. Shapiro says that this is being dealt with differently because it's a same-sex couple.
The answer is...
What do you have to say to that?
The answer is that they chose to put the apartment as joint tenants with right of survivorship.
But at the time that happened, same-sex marriage wasn't legal so there was no other option.
No, I'm sorry. Yes, there was. They could have done it tenants in common, which would have given a 50-50 interest to both parties. That was not done, specifically not done. All that was given was a right of survivorship. And as the evidence showed below, it was done because Dr. Gulick wanted to make sure that his partner had a right of survivorship in the apartment, not to give him a 50% interest. At that time, all he gave him, it was a $1 transfer. All he gave him was the right to a right of survivorship. They specifically did not choose to make it tenants in common. And that's an important distinction, and a distinction that Mr. Shapiro confuses.
But that's a distinction made now, today, during this case, not something that was put in writing then. Is that correct?
They had a choice at that point.
I asked you a specific question.
Was it something that they put in writing?
I said that's something that was said now in this action. It's not something that was done before, put in any writing.
I disagree with the contention. They specifically chose to.
It's a question.
No, the way that they transferred title was specifically giving the rights of survivorship. It wasn't exchanging equal rights in the property. At that point, my client, it was his property. He had paid all the expenses towards it. He had continued to pay all the expenses towards it. From the transfer on, he continued to pay 97% of the expenses towards the property. They then later got married. The panel identified the fact that
I understand that. My question simply was, the explanation was given now. I know it was a joint tenancy with the right of survivorship. What I asked you was whether or not, at that time, there was any explanation in writing as to why that was chosen. I understand what was paid, how it was paid, and how it proceeded years later.
Beyond the transaction documents, no, Your Honor, it wasn't.
Now, Counselor, your adversary, I think at least in his papers, brings out the argument that by operation of law, he immediately got one half, citing to a couple of cases. Now, I understand the context of those cases was different. How do you respond to that?
I think that he cited to tenancy in common law. He cites to the Chang case and the Laney case, which is tenants in common, the transferring of title is tenants in common.
What about the Prospect Capital case? Was that, I thought, that's not the same, right?
I'm sorry?
The Prospect Capital case.
Costco Capital case, no, that's not the same case. In fact, the joint tenants' right of survivorship deals with the Furnace case, speaks to it, that you only get the right of survivorship. And I see that my time is becoming limited. If the panel doesn't have more questions on the
I have
partition issue, I'll go to the abusive process.
Well, I would rather that you address the non-monetary equitable contributions. If you could talk about the 20% interest that was awarded, whether or not we should disturb that.
After 9 days of trial, the special referee heard testimony and awarded Mr. Beckett 7% of the appreciable interest in the property, and that was based on economic contributions. The lower court then, on affirmance, or when they asked the report to be confirmed, increased that to 20%. And what the lower court said is that they did take into account that there were some non-economic contributions given during the course of the relationship.
So why shouldn't that be 50%? Because the defendant, as I understand it, did all the household work, et cetera, while your client earned the income. That has value, doesn't it?
I think it has limited value. I think on balance, during the course of their relationship, there was very limited non-economic contributions given. And in fact, during their 4-year marriage, Mr. Beckett was unfortunately subjected to alcoholism. He was an alcoholic. There were negative contributions, quite frankly. And then, as discussed in our brief, when the divorce was about to commence, Mr. Beckett staged a domestic violence incident, inflicted injuries upon himself, called the police, had my client arrested, had him excluded from his apartment for 18 months, and then spent the next 4 years of litigation doing everything in his power to put pressure on my client to increase his share in the apartment. I mean, the lower court, there's a holding from the lower court that's specific.
Yes, we're aware of that. I want to ask you one question with regard to something you said about the 4-year marriage and the abuse of alcohol. When did the abuse of alcohol begin? I doubt it began upon
No, it began within the first year of their marriage, and Dr. Gulick spent the next 3 years trying to help his husband, staging interventions, doing everything within his power. Mr. Beckett was not receptive. They started sleeping in separate rooms.
Yes,
9
I'm
months
aware that
before-
happened toward the end. But the contributions were, how many years were they together prior to that time?
They were together since the late 90s, Your Honor.
So presumably he was contributing to the household for those years.
To the extent that that correlates to an interest within the property, I contend that that doesn't. That's not the law of joint tenancy. That's not the law of partition. There were, on a purely economic basis, he was not contributing much of anything. And yes, they didn't have a child together. To some extent, they were living together, but that doesn't correlate. And I think the lower court spoke to that in the decision.
Well, you just said that those things wouldn't go to the value of the property. Having a child together would go to the value of the property?
No, I think that it would show to some extent non-economic contributions that might be
There were
considered
non-economic contributions that he made. He didn't have to have a child to make the contributions that they needed to live together.
I think that the lower court took into consideration the non-economic contributions, both at the trial level and then when it came up to Justice Dawson, and that's where the 20% ultimately came from.
Thank you.
The term joint tenant with right of survivorship was also used by the parties, as the record shows, in their bank accounts. And that's a bank account they divided equally. And I don't think it's fair to be so formalistic, because the equitable distribution law, and I know it's not equitable distribution law, but it's partition and it's an equitable remedy. Title is not relevant. These are not commercial transactions that I'm sure the court gets a lot of. The second point is the court gave the same percentage of the marital property. That was a 4-year marriage because their constitutional rights were violated. He got 20% of the marital property. They were together for over 20 years. He was untitled to the property. It's the same 20%. That doesn't make any sense at all. Third, the case that shows that, and I cited in my brief, in my reply brief, and is ignored by my adversary, is In re Covert, which was actually mentioned by the court in a decision this year, which says that the joint tenancy is an immediate interest. There's two parts of it. And with respect to second guessing, the appellate courts are very clear. We don't second guess choices parties made. They had a long relationship. They got married. I don't want to attack the plaintiff, but there was reasons in the record that led to the demise. Thank you.
Thank you both. Meduse versus Plaza Construction.
Good afternoon. May it please the court. Patrick Lawless for the defendant appellant. We respectfully request that this court reverse the order of the Supreme Court which granted the plaintiff partial summary judgment on his labor law 240 subsection 1 claim. The evidence shows that at the time of the accident, the plaintiff was exposed to the ordinary dangers of a construction site and not the extraordinary elevation-related risks that are covered under the statute. The case law makes clear that in situations such as this, where a worker is unloading materials off a flatbed truck and they're not being hoisted by ropes or pulleys, that it is not covered under labor law 240 subsection.
Let me ask you, counsel. I know you cite a line of cases that deal with flatbed trucks, but in this instance, plaintiff was on top of dunnage, right? So isn't there an argument to be made that it was the failure of the dunnage to support the load which caused him to fall?
Well, according to the plaintiff, it's plaintiff's testimony that there was dunnage, but there was also metal bands around it. But this isn't a situation where the materials came completely loose and the alleged failure of the dunnage caused the materials to fall on top of them. It's not like a Walensky.
But is that a requirement that the object has to hit the plaintiff? I mean, isn't there a line of cases? Well, actually, one that comes to mind is Runner.
It's not a runner situation. First of all, in Runner, that was something that was being hoisted from one level to the next. And in this case, the plaintiff, it didn't fall. What the plaintiff said was there were still these metal bands that were heavy-duty metal bands, according to the plaintiff, that were still securing the load. And he said when a dunnage, it just made it unwieldy.
Was the plaintiff on top of those piles?
He was on top of a pile, but...
he was on top of the pile, which looked to be about 2 feet, at least to me, and then lifting from another pile higher than that. These piles, these bundles, were 200 to 300 pounds?
Well,
is that right?
According to the plaintiff, correct.
Okay, well, all right, according to you?
No, according to the,
Okay, so it's 200 to 300 pounds, and the thing that's supposed to keep them together, the band or whatever, gives way, and the weight, the 200, 300 pounds, plus the gravity, flips him over and pulls him to the ground,
Well,
falls on his shoulder.
that's one version. The plaintiff gave several versions of the accident during his testimony.
Okay, well,
According to one version, that's what happened. According to
that
another
would be
version, what the
consistent with
plaintiff
runner.
said was,
That would be consistent with runner.
but what, according to the plaintiff, another version of the plaintiff was that the dunnage snapped, but the band was still around it, it became unwieldy, and he threw it to the ground, and then he fell on top of it. That's one version. Another version is he said it hit his knee, and then he flipped around. But under either version,
It sounds like under, right, what you were going to say, under either version, it sounds like what it was that was supposed to hold it together didn't hold it together. The weight caused him either the thing to hit his knee as it was taking him down and he flipped, or the second version you said?
second version was that the metal bands were still around it, it didn't come apart, but he said,
But it gave way. It
it didn't
buckled.
get, he said it
buckled.
bowed a little bit, and he just dropped it to the ground, and then he fell on top of it. That's not a runner-type situation. I think that if you look at the Berg case from the Court of Appeals, this is almost identical to that, because in the Berg case, the plaintiff in Berg was standing, I think, at a higher level. I think he was standing on top of materials about 8 feet off the ground, and whatever was holding those materials together gave way, or they weren't banded together, and they came loose, and they rolled against him, and causing him to fall. That's almost identical to what happened here.
But
And the
counsel,
plaintiff was just sliding materials onto
counsel.
the thing. It wasn't being lifted.
Counsel, now you're talking about the Berg case, but I don't believe that the Berg case even addressed the issue of whether that fall to the ground from the top of Apollo materials was an elevated related risk. The Court of Appeals didn't even address that. Did they?
It said, well, the Court of Appeals said it was an ordinary construction danger and it wasn't an elevated related risk.
No, but did they actually address that? Because I read it and I didn't see it.
Well, they said, I mean, the Court of Appeals held that that was not a 240
Because
case.
really what the issue was, that the plaintiff failed to present an issue of fact as to whether the fall related from the lack of a safety device in Berg. That's what they said.
Well, I would argue it's the same issue here. The plaintiff has failed to demonstrate that this accident was caused by the lack of a safety
Well,
device.
can I respond to that? Isn't it a fact that, at least the plaintiff testified, maybe it's not a fact, that in fact, in other job sites, they use forklifts to remove the materials from the flatbed.
And in fact, just to add to my colleague, after the fall, I think they came in with a forklift to remove the rest of it.
Well, the plaintiff said that they use forklifts at the other site, but at this particular site, this is the method that they use. They use it on other occasions. And I don't think the plaintiff is qualified to give an expert opinion as what the standard or what's required. The plaintiff was relatively inexperienced, and he just said at one other particular job site that he worked at, they used forklifts, and at this site, they didn't use forklifts, and they'd done it by this method on prior occasions without any issues, and he and his coworkers never requested a forklift.
And then how do you respond to my colleague's point that a forklift was used after the accident?
That a forklift may have been used after the accident doesn't make it that this was a necessary device that was to be used. And the testimony about the forklift being used after the accident, I think is equivocal at best. At the very least, I would say there's sufficient issues of fact that would have warranted the denial of the motion for summary judgment.
Thank you.
Thank you.
Good afternoon, Your Honors, and may it please the Court. Kenneth Gorman for the plaintiff respondent. I think one thing that the defendants are overlooking is that the flatbed in this case was flush with the ground, and that the only height differential was that the plaintiff was standing on a bundle of metal framing. So if that bundle was removed from the flatbed, all of the arguments that my adversary makes would be academic. And more importantly, although flatbed trucks do not present the kind of elevation-related risks that the statute contemplates in this case, the accident was caused by a falling object, or at least precipitated by a falling object, which fell on the plaintiff, who was standing on a pile of metal frames, which distinguishes this case from Topher and Berg. In Topher, the plaintiff was working on a large, stable surface, which was only 4 feet from the ground, and the injury was caused by an unexplained launch of an object, not a falling object, in plaintiff's direction. And in Berg, the plaintiff's accident was caused by rolling trusses that were improperly moved by a forklift, not the lack of a safety device contemplated by the statute. Directly on point is Norton versus New York City. And just as the plaintiff in Norton had to stand on a bundle of wall panels while unloading the bundles from a flatbed truck by attaching them to a crane, the plaintiff in this case had to stand on a bundle of metal framing on the flatbed to manually hoist a 300-pound bundle onto an A-frame cart. And just as the plaintiff in Norton was injured when the bundle he attached to the crane became unstable.
But in this case, and it's a point that your adversary makes, that object did not strike the plaintiff. Does that matter?
It did fall on him. I thought it fell on his knee. And when it became unstable, it caused him to lose his balance, which caused him in turn to fall off this makeshift scaffold that he was standing on.
But you're saying it fell and it struck his knee because he lost his balance and then was propelled off of the flatbed, correct?
Yes.
So it struck his knee once he was on the ground.
No,
It wasn't the striking of the knee that caused him to
I believe it
fall.
struck him when he was on the pile of metal framing, and then it struck him again when he fell on the ground. It caused him to lose his balance, which caused him to fall off that makeshift scaffold that he was standing on. In Flores versus Metropolitan Transit Authority, this court granted the plaintiff summary judgment when he fell off a flatbed truck after a load of steel beams, which was hoisted above him on a crane, swung towards him, just as that steel beam swung towards the plaintiff. In this case, the metal framing struck the plaintiff in this case and caused him to fall off. And also, just one more thing, in Flores, this court cited to its prior opinion in McLean versus Tishman Construction Corporation, where the plaintiff was injured when a metal beam, while being placed on a flatbed truck, fell off the blades of the forklift, hitting the plaintiff's foot and causing him to fall off the truck. The defendants in that case, who are also represented by the same attorneys in this case, argued that this was not a label at 240 case because the plaintiff fell from a truck. The court rejected the defendant's arguments in that case and found that Berg and Topher were not applicable since they did not involve objects falling on or towards workers on flatbeds, but workers falling from flatbeds, implicating only the adequacy of the safety devices for falling workers, which is not an issue in this case. Making this case even more egregious was that it did implicate a safety device for falling workers because that scaffold, that makeshift scaffold that the plaintiff was standing on was clearly insufficient. If there's any further questions, I'll
Okay, thank you very much.
rest on. Thank you.
I'd just like to briefly address the cases cited by the plaintiff because the court below heavily relied upon us, particularly the Norton decision. The Norton decision is completely inapplicable to this case. That was a case where the plaintiff was standing on top of wall panels about 25 feet off the ground while wall panels were being hoisted above his head by a crane. And as the wall panel was swinging towards him, he tried to retreat to get away from it, but couldn't come down because he needed a ladder to climb down, given the height that he was at. And that was the situation in that case. In this case, the plaintiff was standing about 3 or 4 feet off the ground on top of the material. It's not a makeshift scaffolding or platform, as the plaintiff tries to characterize it. And again, I think that...
What about runner? Why isn't runner applicable to it? Isn't the harm here, it flows from the application of gravity, which pulled plaintiff to the ground?
Well, I think given his testimony, it's at the very least unclear what happened because, again, I think he gave confusing testimony. One case he said it abode and then sort of struck his knee, but not that hard and caused him to fall. Another
That's
time
not
he said
inconsistent. That's not inconsistent that it bowed and struck his knee.
But another point he was saying that it became difficult for him to hold and he
That's
threw
when
it
it
down and then
bowed.
fell. I'm sorry?
That's when it bowed.
But it didn't fall, it didn't strike him. It wasn't the case of a falling object. And in runner, it's completely different where an object, a heavy object, was being hoisted from one level to the next, and that wasn't the case here. The plaintiff was holding it at waist level. So it wasn't something that was falling or being lowered to another level at that particular time. The plaintiff was, when he was trying to slide it, it was at waist level when it apparently bowed.
Okay, the whole reason he was holding it was to get it from where he was on this pile to below the pile to the area that was on the landing equal with the flatbed, right?
Yeah, but he was sliding it onto the A-frame that was positioned next to the flatbed. But at the time of the alleged accident, according to the plaintiff, it was
Well, if he was
bundle
holding it,
around waist level.
if he was holding it at waist level, he wasn't sliding it. He had to lift it up before he could get it over.
Well, he hadn't lifted it up. He was in the process of lifting it up to straighten it out. That's what he was doing.
And it pulled him over.
But at the time he said that it bowed, it was at waist level and maybe or not struck his knee and caused him to fall, or either just, he said, became unwieldy and then he dropped it and then fell on top of it.
Thank you.
And just one last point at the very
No,
least.
I don't think so.
Okay.
I gave you a lot of extra time. Thank you. Thank you both. .303 West 122 versus Morton.
Good afternoon, if it pleases the court. My name is Paul Gruber. I'm with Bora Goldstein, Altshuler, Naines, and Goydell, PC. We represent the respondents, appellants, the board elected at the 2020 election in this HDFC. I think it's important to keep in mind here that the landscape upon which this 2020 election occurred was in large part affected by the prior boards. Some of the members are the petitioners and brought this proceeding rather. It was under that watch, all the documents were prepared. It was under that watch, these 4 apartments were permitted to languish without.
That may be so.
Yes.
That may be so, but the bylaws indicate certain requirements, and that's what has to be met, right? So why don't you speak to the number of shareholders and the apartments that they came from and what shares they held
Well, each
that either met the bylaws or didn't at the meeting in question.
All right. I'm going to get back to my other point after that. There are 42 units in this building, and there are 8 apartments that are controlled by the co-op. They're either rented or occupied by the super or vacant. They're not counted in terms of an election.
Let me ask you this. You agree, you and co-counsel, both parties agree that there were 30 that were 30 shareholders or 30 apartments that were,
yes,
right? There are 30 that were allowed to be considered for voting. Right?
Absolutely, 30.
And there was a question about 5.
There was a question
Why
about
don't you
4 or
talk-
5, yes.
Address those 4 or 5.
Okay. Those apartments were apartments where there were the shareholder was deceased and there was no administrator for the estate. It was our position, still remains our position, that there's no one to exercise any right for those apartments. They shouldn't be counted.
Counsel, was there any express language in the bylaws that reflected that those apartments should not be counted?
No, there was nothing in there. However, this is
So
where...
what does that mean then with
What does that
regard
mean
to
is
those?
that...
Just let me finish my question.
Sure.
With regard to whether those would be outstanding or whether they reverted back to the HDFC.
It's one of the questions that the parties stipulated that should be resolved by Justice Rackauer in the hearing she directed to determine who was eligible to vote, which she did not hold. We think that's one error that was committed here, but I think there's a broader point that could be looked at. When a BCL 619 proceeding is considered equitable in nature, and this is a court of equity like the other half of the Supreme Court that heard this case beforehand. And you know, we cannot rule out the equities here. The documents in the record submitted by the appellants, to this point unrebutted, allege a long pattern of mismanagement by an incumbent board shared by a few members.
I'm sorry, Counselor, I understand that, but you're not really addressing the question asked. I mean, how can we sort of ignore the bylaws?
No, you don't ignore the bylaws.
And
you
isn't
interpret
there a
the
remedy
bylaws.
here, frankly, with respect to getting maybe a public administrator appointed or whatever needs to be done?
Well, of course there's something to do. Of course there's a way to get the public administrator involved, but if you have a board that historically did not appear interested in doing that for whatever reason, what are the other shareholders are supposed to do? I think at the end of the day, the courts really want to avoid a situation where you have an HDFC, which were originally designed for low-income tenancies in order to give them some equity, from being in situations like this ad infinitum. The relief we're requesting is that, one, the court confirm the result of the 2020 election. It's an election. Every year there's a new one. There's a new one. Alternatively, we ask that the court send it back for Justice Rackhauer to consider what the parties decided were important and hold the hearing that she said she was going to hold.
Thank you.
Okay, thank you.
You have rebuttal time.
Good afternoon, Your Honors. May it please the court. My name is Joseph Altman. I represent the respondents in this appeal.
Mr. Altman, what about the equities? The old board can take the position, well, we're not going to do anything with respect to the apartments where the shareholders are deceased, and maybe create a situation where a quorum can't be ever achieved, which permits the old board to continue.
Well,
does that seem
equitable?
Fair?
Well, Your Honors, equity is really not the issue here. The issue was and still is, what does or do the bylaws say? And the bylaws say exactly what Judge Rackhauer said. We spent a very long time trying to figure out.
But if it's your actions, if it's the board's actions at this point, because it's convenient to the board not to have a quorum, that's causing this situation, isn't that an issue here?
No, because you could have a quorum. That's not the issue. This is not an issue to amend the bylaws, to say that you couldn't have a quorum. It's a very simple issue that we brought in the petition. The petition says there was not a quorum and it was an improper election. So you can't cure it by having an improper election. I mean, is that equity? So two wrongs make it right? Is that what counsel is saying? I mean, that argument has to just fly right out of this court.
So if we affirm that essentially allows your client, the old board, to sort of continue in this fashion, not get estates represented to the public administrator or whatever, and your side holds on forever.
Well, that really wasn't the issue in the court below. They didn't bring, their issue was they had a valid election, that they had a quorum. And it wasn't to say that there was an impossibility to have a quorum. Respondents came into this case thinking that they had a quorum. And until you sat down and you went through each apartment by apartment, and then Judge Rackhauer said, hey, look, when we looked at it, you got 35 apartments, at best 17 people showed up, so you couldn't have a quorum according to the bylaws. You can bring a proceeding to say the bylaws have to be amended. You could bring a proceeding saying these people who are deceased, we have to go to court to do what's necessary, but that's not this proceeding. They simply said that they had a valid quorum There were people that showed up and they won. So the alternative is they stay in power forever. I mean, is that the alternative? No. You have to read the rules, and whoever is in power holds an election, and you see who shows up. The fact of the matter is, you could have people show up, and you could make a quorum. You could. It's not something that goes on forever, but the equitable result is not to have an argument that really wasn't raised when, and their argument is, well, you're wrong, but we're better than you, and we should stay forever too. And notably, the election that should have been held wasn't. And anything that counsel says about their group being better than the petitioner, that wasn't before the court. We didn't get into that. The court didn't want to have arguments as who is better to run the building. The court simply said, is there a quorum? Because that was the petition that was before. And look at their cross petition. They didn't say anything about what they're arguing here. And the court is correct, as Judge Renwick said. They didn't have it. So the court below decision has to be affirmed.
Thank you.
I think Justice Singh, in his questions to the respondent's attorney, got to the point that we were trying to make. And I also want to just point
But on
out.
the other hand, if we do that, we're rewriting the bylaws.
No, we're not.
Is that our role here?
No, we're not. We're interpreting the bylaws to respond to a situation which, frankly, should have never existed. This is an HDFC. It's not the most sophisticated of co-ops. You know, the parties were able to agree on issues that they thought were important to ask the court to decide, and for whatever reason, she didn't want to decide them. We're not arguing that we're better. We're not arguing. I mean, that's ultimately going to be judged by the other shareholders in the cooperative when there's an election. That's simply as that. That's not our point that we should win because we're better. I can't say that our clients have really proven it in this past year yet, and I can't say that they've disproven that either. What I am trying to say is that this court has equitable powers, there are clearly equities here, and that a rote finger counting here works an injustice to the other shareholders of this cooperative as well as my client. On that note, we ask the court to modify, reverse, or remand. Thank you very much.
Thank you. Thank you both. Atlas versus Macquarie, Texas.
Good afternoon. May it please the court, Stephen Meister, Seelig, and Fine for the appellant. Your Honors, in response to the HUD 96-day provision, which is mentioned in our brief, the court below wrote these words: if there were any delay from HUD, the winning bidder could have requested a rejection from HUD. And that was quoting the respondent's expert, Mr. Vaughn. And then the court continues, thus, even if the HUD approval approached the 96-day mark, the selected bidder could simply get a HUD rejection letter rather than risk its deposit. That's at Appendix 35, decision page 31. Your Honors, that was a blatant error. The court failed to consider the underlying contract that Macquarie had prepared and put into the data room. That contract provided that it was a default if the bidder, quote, fails to diligently pursue the consent of HUD, and that the deposit could only be returned, which was over $8 million in 2 installments, if the purchaser had engaged in diligent, consistent, good faith efforts to obtain HUD's consent. I would also mention that when
Is that, counsel, is that the linchpin of the court's decision below?
I think it was an important part of the decision. I think there is a tapestry of facts, which I'm happy to get to, Justice Singh. But I do want to point out that during my cross-examination of Mr. Vaughn, I asked questions directed at this contract, so the court should have been aware of it. And it is just blatantly wrong to say that a bidder could have asked for a rejection. That would have been a default under the contract. In addition, Your Honors, this 96...
Counsel, didn't the sale terms require that the selected bidder make a deposit by certified check or bank check?
It was Your Honor...
Was your client able to do that?
I'm sorry.
Was your client in a position to do that if they had been selected?
There was a requirement that the selected bidder deposit a check for $4.8 million. The nub of our claim is that a commercially unreasonable sale process was run, which is really completely separate, in other words, from a claim that we should have been the winning bidder, okay? That's the question.
So let's go to the heart of the issue.
Just for clarification, I just want you to be aware that question came from Justice Pitt.
I'm sorry.
I saw you looking at me, and I thought
it's hard with the
sometimes
mask.
you can't tell who's speaking with the mask.
I beg your pardon, Your Honors.
It's like we're ventriloquists or something.
Right.
I know.
So to the issue of commercial reasonableness, how much time was there between the default, the sale? Wasn't there an email blast? These are all issues that were covered in trial, right?
You know what, Justice Singh? I'm glad you raised that, because there was an email blast to something like 8,400 people, or 8,400 investors, if I remember the data point correctly, and only one of them bid, okay? And not one bidder, including KKR, agreed to this 96-day provision. KKR demanded, in contravention of the procedures, that the 96-day provision become 210 days, 7 months. That's more than double the time. Then you have a $90 million profit flipping here. You have here, there was a transaction where Macquarie offered to pay $30 million over the debt a year or so prior to the sale. That transaction didn't consummate.
But that horse already left the barn. I mean, we're beyond that. We're at the auction now.
But I'm saying that there's evidence of predatory intent. There's all the emails, which I'm not going to bother to recite, that are in the record and in my briefing. There's a $30 million, there's an effort to pay $30 million by Macquarie over the loan. There's, by KKR to pay to Macquarie, and Macquarie turns it down. They say, we don't want to sell you the loan. And then there was an effort by Macquarie to buy the equity partner out for $30 million.
But ultimately, that never came to pass, correct?
But you have this 96-day provision, which chills all the bidding on top of this tapestry of facts showing a predatory intent, okay? You have a $90 million flip profit here. That was my client's surplus. The reason that surplus was left on the table was because they designed a provision that no bidder could possibly accept, and no bidder did accept. And so there was, and of course, as we point out, the court absolutely got the burden of proof wrong, and that's a critical point here. The statute is crystal clear. There is no way to read this statute other than placing the burden of proof on Macquarie in this context once my client places it an issue, which is, of course, exactly what this proceeding was. So you have all this predatory intent. You have the $30 million offer on top of the loan. You have them turning down the Macquarie KKR trying to buy the loan. You then have a 96-day provision and a 21-day provision that scares away every bidder, and then you have the properties flipped with no improvements and no real significant market appreciation for $90 million more, and there's a burden of proof.
And that was 2 years later, correct?
Not exactly, Your Honor. We don't know. It was because there was a motion to quash a subpoena. We took an affidavit. I couldn't raise the questions. We know that 3 deals were sold at some point within 2 years. those 3 deals could have been sold much closer than 2 years, and the other 7 deals were in contract, but it's not in the record when they went into contract. But there was no evidence, Your Honor, of any significant improvements and no evidence of intervening market appreciation. The market was relatively flat during that period. And by the way, if one of the 3 closed deals sold pretty close to the sale, we could have just extrapolate on a per unit
But with
basis.
respect to these issues, and I apologize for asking questions over the red light.
Okay.
There was competing expert testimony, right?
Yes, but the competing expert testimony, talking about the expert testimony about value?
Yeah.
Okay, but the most salient evidence of value is what a willing buyer pays to a willing seller. All appraisers do, Your Honor, as you know, is try to estimate what that will be. So when we found out during the middle of the trial that 10 of 11 properties had been flipped for essentially $160 million or $163 million as to their $76.75 million investment, as far as I'm concerned, that superseded the valuation testimony because I had a real market transaction. Now, yes, you could say it was 2 years, up to 2 years, but then given the burden of proof, there should have been evidence to contextualize that sale. Oh, we made a lot of improvements, or KKR made a lot of improvements, or there was intervening market appreciation. McCrory put in none of that evidence despite having the burden of proof, although...
So you're saying, so this is, to your point, you're saying that KKR's bid was too low. They shouldn't have accepted the bid because it was too low, because they were able to flip with less than 2 years with a flat market?
What I'm saying, Justice Renwick, is that if McCrory had run a non-corrupted process, there would have been other bidders, and it would have gotten bid up to $160 million.
Because, I mean, your bid was close to what KKR's bid was.
My bid...
I mean, your client's bid,
$77 million against $76.75 million, and then KKR stopped bidding. That doesn't mean we would have stopped bidding if they kept bidding, but KKR stopped bidding. There was only one...
You would have bid up to the amount that property was sold for, that those properties were sold for?
I can't
Well,
say
I'm just
what-
saying that you're saying that that was, you know, it was outlandish, but because
the
it was...
essence of a claim for a commercially unreasonable sale is that there is inadequate bidding at the auction.
I understand. I was just testing your point about the value of this that you were saying
Yes,
in
I
2
think we
years.
would have kept bidding, but of course, there's no evidence in the record of that because we outbid by the requisite $250,000 increment, the last highest bid by KKR, which was $76,750, but there was no other bidder.
I understand. Let's hear from your opponent. I understand what you're saying.
Good afternoon. May it please the court, Gary Mennett for defendant, respondent, Macquarie, Texas loan holder. This appeal presents 3 questions, and the answer to each results in an affirmance. First, the law is clear that this court need not resolve the burden of proof issue that Mr. Meister referred to.
But who has the burden in this case? Doesn't the UCC suggest that the secured party has to establish compliance with the section?
Your Honor, that you're referring to Section 626 of the UCC.
That's correct.
And that says that where the amount of a deficiency or surplus is an issue, that we have the burden of proof, and we don't disagree with that. We don't dispute that. And in fact, there is an issue in this case that remains to be decided by the lower court concerning who gets the surplus. And who gets the surplus is an issue that's governed by Section 615 of the UCC. And what 615 of the UCC says in substance is you take the cash proceeds of the disposition. Here, there was a sale to a third party, KKR, for more than the amount that was owed by Atlas to my client, to Macquarie. You take that amount, and then Macquarie, the bank, the lender, can deduct from that amount the amount of the debt, obviously, also any interest that accrues between the time of the auction and the closing, attorney's fees, et cetera. There was, because this was a relatively unusual situation where the sale price was actually higher than the amount of the debt, there is a surplus. And with respect to that issue, we do have the burden of proof, and Justice Cohen so held, but the claim that Justice Cohen held the trial concerning is a claim not under 626, it's a claim under 625, which is 625B, which is damages for noncompliance. It's not a claim to a surplus, it is a claim to an amount beyond the surplus. What they're saying is that, and this goes to the point that Justice Renwick drew out in her question, the sale to KKR was for an amount in excess of the debt, and then KKR sold the properties years later for a higher amount. They're claiming that that higher amount could have been achieved. So they're saying that the surplus should have been more. And 615F does talk about that type of claim, but in the surplus itself is only deemed to have been increased if the sale is to a related party. And here it was not to a related party. It was to Macquarie and KKR, completely unrelated. And so the amount of the surplus is absolutely fixed. It is the difference between what the property sold for and the amount that was owed. And so with that, we have the burden of proof, but anything beyond that, they have the burden of proof. Justice Cohen did a very nice job of analyzing this, and it's in the appendix at page 28, page 24 of his decision. There are 4 cases directly on point, one in the 6th Circuit, one in the 10th Circuit, 2 federal cases, the Nebraska High Court, the Oklahoma High Court, and then UCC treatise. All of those sources, 4 cases and the treatise, they all agree that on this case, they have the burden of proof, that the plaintiff, debtor, seeking more than the surplus has the burden of proof. There's no New York case on point, but all of that case law indicates the same outcome. But in any event, as I started to say, the court need not reach that issue because Justice Cohen expressly made a protective ruling and said whether Macquarie has the burden of proof or not, they prevail. That he said this is potentially an appellate issue because there's no New York case directly on point, and so he expressly said that twice in his decision.
But just to be clear, the UCC, this section we're talking about, was enacted in 2001, right? So most of the cases you mentioned were before that?
Some of the cases were before that, but on this point, that the surplus is the difference between the amount that's generated at the auction.
You're saying it's not applicable?
Right, the changes,
I understand
that was not changed. That is like a very bedrock thing in the UCC that was there before the changes. Unless the panel has any questions about the burden of proof or the protective rulings, the one other thing, the third question is whether the trial court's findings of fact could be reached under any fair interpretation of the evidence, and we submit that Justice Cohen's 41-page decision, which was after 6 days of trial, 11 witnesses. This was pre-pandemic, so it was a live trial. 2 interlocutory appeals to this court. That was more than a fair interpretation of the evidence. We submit that it was the only rational outcome.
Thank you.
Thank you. We'll rest on our papers.
Your Honors, Section 9626, which in relevant part says if the secured party's compliance is placed in issue, the secured party has the burden of establishing, and I'm cutting out some irrelevant words, the disposition was conducted in accordance with this part.
So in this case, at least down below, Justice Cohen hedged his bet, right? He did it under both alternatives.
He did.
Let's assume that so my question is assuming that he was wrong, how was it, the sale wasn't commercially reasonable?
Because, Your Honor, following a slew of emails, and I've never seen emails like this. I've tried a lot of these cases that say things like, can we get to own this? And let's have these discussions offline. And they went so far as to alter the CBRE commission agreement to reduce the extra commission CBRE got for bringing a cash buyer. They turned down KKR's loan to buy the loan, KKR's offer to buy the loan at par. They tried to buy the actual partner out for $30 million. On top of that, they now put in this provision that says if in 96 days, HUD does not either approve or disapprove, you lose your 8 and change million, or if you don't assume the HUD loans, you got 21 days to close 11 mortgage loans. No bidders come. No bidders come except for one hyper-aggressive Wall Street firm who then says, after the bidding is over and they won, oh, by the way, I'm not agreeing to that ridiculous onerous clause. I want 210 days, not 96.
Did Mr. Meister, did the bidding instructions permit defendant to accept comments to the sale? So
it did not permit the radical alteration, Judge. That is in no way a fair reading. None of the other bidders thought they had 210 days. Some of them explicitly said, we're not bidding because of the 96 days. Not one bidder accepted 96 days, not one, and the deal was flipped for a $90 million profit. The judge is wrong on the burden of proof. 9626 comes right after 9625, which says that we can recover any damages for noncompliance with the article. And I would respectfully direct the court's attention. There's a UCC comment that I think one of the official commentaries to 9625 that addresses this, that says in substance, only when a competing lienor is seeking damages from a commercially unreasonable sale, because it could be damaged as a junior lienor, do the, quote, normal rules of pleading and proof apply. That's what the comment 3 to 9625 says. 9626 doesn't say, as it easily could have, this doesn't apply to a 9625 claim. It only applies to a 9615 calculation of surplus claim. Doesn't say that. So the judge got the burden of proof wrong, and the findings are contrary to the factual evidence. None of this is credibility assessment. All the facts that I've discussed in my presentation are undisputed facts of record. The 96 days, the 21 days, the emails, the $30 million deal, turning down KKR's offer. Those are all objective facts in the record. Unless the court has further questions, we'll rest on our briefing.
Thank you.
Thank you very much.
Thank you both. People versus Levon Jackson.
May it please the court. Tyler Goodcone from the Office of the Appellate Defender for Mr. Levon Jackson. Mr. Jackson is a 35-year-old first-time felony offender with 2 young children who is sincerely remorseful for his actions. Mr. Jackson has already served 3.5 years of his 12-year sentence, a sentence nearly 2.5 times higher than the statutory minimum. To both individualize Mr. Jackson and account for his sentencing disparity, this court should reduce his sentence in the interest of justice to 8 years and 2.5 years of post-release supervision.
At the trial court level, the people were originally offering 15 years, is that correct?
That's correct.
And then he got the benefit of the plea bargain at 12 years, correct?
That's correct.
Why isn't the trial court in the best position to assess, the appropriate sentence, because they have the defendant there in front of them, they have the entire record? Why should we disturb that?
Well, a couple of things, Your Honor. Firstly, in People v. Delgado, the Court of Appeals explicitly stated that this court has the option to substitute its discretion in the interest of justice of that of the sentencing court. Secondly, Your Honor, you should, in particular, because of the sentencing disparity in this case, Mr. Shaquille Shepard, a co-defendant of Mr. Jackson, received a sentence of 7.5 years, nearly 5 years more than Mr. Jackson. He was a procurer and supplier of the weapons who brought them from South Carolina up to New York, and he received a sentence of 5 years less. He was also facing an additional 2 Class C felonies, more than Mr. Jackson.
So we do have our interest of justice jurisdiction, and here there is no waiver that we are stopped by. But how many guns did his co-defendant have?
Your Honor, he was facing 17 counts of criminal sale of a firearm in the 3rd degree, and Mr. Jackson was facing 26 counts. A proportionate sentence just based on that disparity, based on the sentence that Mr. Shepard received, would be less than 10.5 years. Mr. Jackson's not a career offender.
So just to answer my question, the other person had fewer guns than Mr. Jackson? Mr. Jackson had 26 separate counts, you said, and the other one had
Yes.
17?
But the other individual was also a procurer and supplier, taking the guns up to New York to give them to street dealers like Mr. Jackson and like Mr. Stuckey, who was the mastermind behind the operation.
And Mr. Jackson did that on one occasion as well?
On one occasion, he was in South Carolina, but Mr. Shepard is the one who gave him the guns in South Carolina. He brought them up to New York, and then after he sold the 2 guns to the undercover, he then wired money to Mr. Shepard for the sale. Mr. Jackson's not a career offender. He was 29 to 30 years old when he engaged in the instant offense, and it's his first felony conviction.
What was he doing before?
Your Honor,
does he have a work
in the record,
history? Does he have...
So he was making music, and there's a record that he had an employment job for a couple of years. And Your Honor, he wrote to the court that he accepted full responsibility for his actions and was truly sorry. He told the court that he committed the crime to provide for his family and wished he had found an honorable way to do so. And his stellar reputation record here shows that he's ready to do just that. While pending his plea and sentence, Mr. Jackson focused on building employable skills for a career in construction through the Fortune Society's Individualized Correction Achievement Network's group housing program. He earned a plethora of OSHA certificates that will assist him in finding a job in construction. He also tried to become a better father by taking workshops in parenting and life skills through the Fortune Society. He even participated in acting classes at the Stella Adler Studio of Acting, where his notable work ethic earned him an internship there upon release to study acting in Midtown.
Counselor, where was your client trafficking the guns? Wasn't it around his apartment?
Your Honor, in the record it says that he was selling in the vicinity of his apartment.
Right, and he has a son in the apartment, a 7-year-old?
Your Honor, yes, he does have a son in the apartment, but there's nothing in the record to suggest, number one, that he's selling out of the apartment, or number two, that he understood or thought that the guns were somehow going to end up in his neighborhood as opposed to somewhere else by selling at a place convenient for him. But more importantly, Your Honor.
Well, did it matter to him where the guns were going to end up when he was selling them?
There's nothing in the record to suggest that he knew where the guns were going to end up.
Well, so that means it's equally as possible that they would end up right there on the street, killing a neighbor or a child, or they go to another neighborhood and kill.
And I don't dispute that, Your Honor. I'm just saying that what Mr. Jackson knew about what was going to happen with the record or with the guns is not in the record. But more importantly, with respect to his child, he clearly has a strong bond with his child and his partner and both of his children. Before incarceration, he was a major source of stability for both his young son and daughter. He spent 5 days a week with them and would pick up his daughter every day from school. Upon release and before he was incarcerated, he plans to return to live with his young son, Jaden, and his partner. He speaks with his son every day, and he's clearly trying to be the best dad that he could still be while incarcerated, including by taking parenting and life skill workshops through the ICANN program.
Counsel, now didn't the police also execute a search warrant in the apartment where he lived with the son and the son's mother, recovered, what, I think 29 bullets and 1 magazine?
Yes, Your Honor. They did not recover any guns in the apartment, though. Given the fact that this is Mr. Jackson's first felony conviction, his remorse, his positive trajectory, and his family support, we would ask this court to reduce his sentence in the interest of justice by several years. Thank you.
That's one more question. You talk about the family support, but obviously he was a father even before. So if he had this family support, that certainly didn't prevent him from selling the 26 guns for like a 2-year period.
Yes, Your Honor. And Mr. Jackson explicitly told the court here in his letter where he expresses remorse. He says that I committed this crime to provide for my family, and he's been doing the most he can in prison to show that he's ready to get a legal job, that he's building his employability record.
How old was the other gentleman, and what kind of record did he have, the co-defendant?
Your Honor, it's not in the record exactly what what his circumstances were.
And when did Mr. Jackson first involve himself in this? How old was he?
He was 29 years old,
And he now is how old?
35 years old, Your Honor.
Okay, thank you.
Thank you.
Good afternoon, Your Honors. Jeannie Campbell-Urban for the People. I have several things to say in response to my adversary's remarks, but I'd like to start with the comparison between this defendant, Mr. Jackson, and Mr. Shepard, the co-defendant, who my adversary has chosen to highlight. This defendant sold 26 guns. Mr. Shepard sold 17. This defendant's participation in the conspiracy was from December of 2015 to March of 2017. Mr. Shepard's December of 2016, i.e. 1 year later, to March of 2017. So Mr. Shepard was only involved for about 2 to 3 months at the tail end, right before this case was taken down by the authorities, whereas Mr. Jackson was involved from a year before that. Mr. Jackson is named in 35 out of the 85 overt acts that are pled in count 1 of the indictment, which is the conspiracy count. Mr. Shepard's name appears in 18. Mr. Jackson is charged in 32 of the 203 counts of the indictment. Mr. Shepard is charged in, I believe, 23. We don't have information about Mr. Shepard's age, his record, or whatever mitigating factors he may have provided to the sentencing court in his case. That's because this record, the defendant appellant has provided us with only the sentencing minutes and the plea minutes from Mr. Jackson's case, so we don't have information that may be out there about Mr. Shepard's individual circumstances. But even if you look at the length of time that these two defendants were involved, the difference in the length of time, I should say, the difference in the number of guns sold, I mean, there's plenty of reasons for why Mr. Jackson got 12 and Mr. Shepard got 7.5. Not to mention the fact that Mr. Jackson is a New York City resident. As this court said, he was selling firearms in the vicinity of his neighborhood, of his apartment, in his own neighborhood where he was living with his 7-year-old son. And as I believe you mentioned, Your Honor, there were 29 bullets of varying calibers recovered from the defendant's apartment where he was living with his son. So it's true that there weren't firearms recovered, but I think that 29 bullets of varying calibers tells you something, and that is that he was, at least in some capacity, bringing his work as a firearms trafficker home to his family. I would also point out that the defendant's mother, her name is Gail Stuckey. She wrote a letter on the defendant's behalf. Shavar Stuckey is the quote-unquote mastermind, according to my adversary. I believe that Mr. Jackson and Mr. Stuckey are related. I think that they're half-brothers. So I think that the argument about having family support cuts both ways. Sure, Mr. Jackson's girlfriend and son and daughter love him, but he was involved in the family business of firearms trafficking, and I just don't think that a sentencing reduction is warranted under those circumstances. If I could just take a minute to look at my notes. Oh, I just wanted to just briefly talk about this idea of Mr. Jackson being a first-time felony offender. That's obviously literally true. This is his first and second felony convictions, but he sold 26 firearms on the streets of New York City. This is not a one-event case, a case where I think it would be more appropriate to argue that this was a first-time felony offense. I mean, the defendant was clearly making a living selling guns. He was charged with numerous counts of doing that in this case, and I don't think that it's persuasive to argue that because it's his first felony conviction, he should get a sentencing reduction. If there are no further questions for me, I will ask that you affirm the 12-year sentence for the reasons in our brief.
Thank you.
Thank you.
Just a couple points, Your Honor. Firstly, with respect to the timeline and the length of involvement of Mr. Shepard and Mr. Jackson, in 3 months, Mr. Shepard managed to engage in 17 firearm sales. Over the course of over a year, Mr. Jackson engaged in 26. It doesn't make Mr. Jackson more culpable just because he engaged in more sales given that in a short period of time, Mr. Shepard clearly engaged in quite a lot of sales, including earning himself an additional 2 Class C felonies. Mr. Shepard's sentence was 7.5 years. He engaged in about 2/3 of the sales of Mr. Jackson. If you were to give Mr. Jackson a proportionate sentence to that, it would be less than 10.5 years. He was also a procurer and supplier. I also want to say it's speculation to say that Mr. Jackson is somehow related to Mr. Stuckey. That's not borne out in the record. Thank you.
Thank you both. Coleman versus Anucci. You may begin.
Good afternoon. My name is Naila Siddiqui on behalf of Mr. David Coleman. Mr. Coleman received a nearly 5-year time assessment for an unconstitutional condition of his supervision. Specifically, he was not permitted to possess a cell phone, a smartphone, access social media websites, and possess legal adult pornographic material.
Actually accurate?
I'm sorry?
Is that accurate factually? Isn't it that he was supposed to get permission from the parole officer before he could access social media, et cetera?
Well, so the ban was that he could not, it was phrased that he could not possess these, well, with respect to the pornographic material, I think there's an absolute ban. And I believe there was also an absolute ban on accessing social media. With respect to the cell phone, it's unclear because at the contested hearing, the parole officer did not go over the extent to which he was not permitted to possess the cell phone, although he was charged with possessing the smartphone.
Well, in the special conditions, was there a complete deprivation of possessing those kind of items, or did he have to get permission?
Well, with respect to these, with respect to the pornographic material and the accessing the internet for the social media websites, there was an absolute deprivation.
But as to the rest?
Oh, with the cell phone, that is unclear. That's not in the record because the parole officer did not testify to the specific condition of the smartphone.
So it's a cell phone, which could be a flip phone, versus a smartphone, which allows you to access other materials.
Yeah, so
and it's the smartphone that he had to have permission for versus a cell phone that you just call somebody?
So it was what they're alleging he possessed was a smartphone. One of point 2 in our brief discusses the sufficiency of the evidence, where they didn't establish the specific condition as to the smartphone, nor did they introduce the smartphone into evidence. But they're alleging that he did possess a smartphone, and that was at issue.
Counsel, were the specifications worded in a way that said that he got a phone and accessed social media without first obtaining the parole's permission? Wasn't that stated in the specifications that was brought against him?
No, I don't. Well, in this court's decision in in matter of Cobb, a parolee was not allowed to go to the entire borough of Queens as a special condition, and they were allowed to get permission from the parole officer to go to Riker specifically to get their property, and there the court held that it was an overly broad condition to not allow the parolee to go to Queens. So
that's not this case.
No, but it's an overbroad condition where there are constitutional implications.
And I'm sorry, can you go to the penalty aspects of the case? And before you start that presentation, what is our standard of review? Is it an abuse of discretion standard, or is it the Pell standard? Because in Article 78, Pell standard being shock to conscience.
It's it's an abuse of discretion standard, and in this case, the the presiding judge, the ALJ, both abused his discretion in a manner that does shock the conscience. It was a draconian trial tax that was 2.5 times the amount he got for his underlying offense. He got 2 years for the actual crime, but 5 years for a purely technical, non-criminal offense. And with respect to...
Well, when you say purely technical, non-criminal, he was charged with a crime. I don't know if you want to use the word criminal. He was charged with this crime, and as a result, he has restrictions. It's not that he can't have a phone. It's that if he's going to have a smartphone that allows him to access materials that you've already said are absolutely banned, then he has to ask permission for use of that smartphone because it's going to give him access to people, to this material, to a whole host of things that it sounds like he's not supposed to have. So that's where that issue came. But you were talking with regard to, speaking with regard to, I think it's, Pell and substantial evidence, and whether there's substantial evidence here to support this offense, this time that he has, or whether this over double time shocks the conscience.
With respect to the evidence, they didn't establish whether or not the conduct, whether or not he accessed the websites after the special condition was imposed. The special condition was imposed on September 5th. He was violated on September 18th. There was no testimony that he accessed those sites during that time period. In fact, the date stamps and the evidence introduced with the pornographic material was in August. So while it was on his phone, it wasn't knowing and volitional, because people can send you messages and you don't know that they're there without actually opening them up.
But he had the phone. You
possessed
may be
the
right.
phone.
He had the phone. So at the time when the parole officer, I guess, found it, he was in violation of that condition, no?
Well, he was in possession of a phone, but he wasn't in knowing possession of what was everywhere in the phone.
But wasn't there testimony here, too, that he had accessed, I guess, websites, particular websites, under false aliases?
Well, so there was testimony that he used dating websites with not his name, but that's not, it's simply accessing the social media websites, but there was no testimony as to when he actually did and whether it was within the period that he was not supposed to. He was released to parole, I believe, in July, and during that time, he was not subject to the special condition. So the special condition was only imposed in September, and so during the almost 2-week period, there's no testimony that that's when he was allowed to access it. And he testified saying that he did access it, but it was years before, and had access to those, or did use those websites, but it was not during the time period that the special condition was imposed, which was simply roughly a 2-week period.
And counsel, with regards to the photographs, you stated that he couldn't control people sending him photographs and that it automatically downloads to the phone. But isn't there some testimony here or evidence that he saved them to another folder?
I'm sorry, I didn't hear the...
Isn't there some evidence here that he saved those photographs to another folder, indicating that he knew that they were on the phone?
I don't believe that that's... So the stamp on the material that was sent was dated in August. So it's unclear where they were located. There was no testimony as to that. Where on the phone. She just introduced photographs with timestamps.
Thank you.
May it please the court, Eric Del Pozo for the New York State Docs. I'll dive right into clear up some of the confusion about the cell phone condition. It was special condition paragraph 35. Wasn't a flat ban on Mr. Coleman's possessing a cell phone. He merely needed to disclose the cell phone to the parole officer and get permission, and this was...
Any cell phone, flip phone.
The special condition says cell phone. The fact that this was a smartphone made it even more troublesome, because Mr. Coleman was only allowed to have one computer, supposed to have one computer, and expressly consent to searches and monitoring by the parole officer. And we understand why, given the facts of this case. Mr. Coleman used the undisclosed cell phone, again, not a flat ban, he just needed to ask permission, to troll dating sites under an alias and coax nude photos from the women with whom he was communicating. Substantial evidence supports
Well,
all of
let's
those
assume
five.
there's a violation, but he's in for the rest of his PRS. I mean, so it's more than doubling the sentence. Isn't that an abuse of discretion if that's our standard?
It isn't an abuse of discretion, nor would it meet the standard from Pell, which is grossly disproportionate and shocking the conscience. Yes, the time assessment was lengthy. Mr. Coleman was held to his maximum expiration date, but the violations were serious, and they showed.
And how were the violations serious? I don't want to minimize them, but how were they serious? It's not as if he was engaging the activity that caused him in the first instance to be incarcerated.
Well, Mr. Coleman was incarcerated on a bump-up felony for having at least 3 non-consensual sexual victims within a 10-year period, excluding periods of imprisonment. So he is a recidivist offender, even though this was one felony conviction. And the conditions here, as applied, were tailored to preventing recidivism. Mr. Coleman, for all we know on this record, could have been gearing up, and his offense cycle could have been restarting. And he deprived these women of the opportunity to know, or at least find out, that he was a level 2 registered sex
And
offender.
just so that I'm clear, when you say it was bumped up, the third one, you're saying 3 and 10 years, and the third one was where he patted someone in the buttocks. Is that right?
That's right, Your Honor. The first 2 could have been felonies. They could have been misdemeanors.
What were they?
The third is made a misdemeanor.
What was the first one? What was the activity?
Unfortunately, there is no evidence in the record.
But
and
you
this
said it was a
administrative record of
misdemeanor?
what the prior
Did you say
crimes
it was
were.
okay. Did you say it was a misdemeanor?
It could have been a misdemeanor, yes.
And the second one?
The second one could also have been a misdemeanor. All 3 could have been misdemeanors, but the statute makes the third a felony given the recidivist aspect.
I understand.
So the time assessment shouldn't be judged just by looking at the length, Your Honor. You also should look at what I'll call the numerator and all of the ingredients that go into it, including the series of violations for which the ALJ found Mr. Coleman to have violated. He committed another set of violations before that for which he was granted a reprieve. He refused a drug test and started acting belligerently in the parole office. Mr. Coleman has an extensive criminal history across several states since age 17, which the ALJ recited in the opinion.
But that's not why he was given the 5 years or the 48 months, is it?
It went into the calculus. The ALJ did cite that as a factor, and this court's decisions allow the ALJ to take that into account. Mr. Coleman also, the transcript makes clear, was acting obstreperously and even threateningly during the revocation hearing, so much so that both the DOC's revocation specialist and the ALJ called for a correction officer.
So I want to be clear on what the violation was. It wasn't that he had a smartphone. It's that he didn't ask for permission to have the phone.
That is right, but it goes even farther, Your Honor. Mr. Coleman flat lied to the parole officer. When the parole officer asked him whether he had a phone, he said no, he didn't. In fact, the parole officer, or a prior officer, before Officer Tucker had inherited the case, confiscated a different undisclosed phone from Mr. Coleman. He claimed it was his sister's. He actually asked for that one back as well. The challenge to this evidence, the substantial evidence objections, all rationally rejected by the ALJ. There is evidence that Mr. Coleman, in fact, had the phone, the undisclosed phone, on him. On September 18th, the parole officer was asked during the revocation hearing whether there was, by Mr. Coleman's counsel, whether there was evidence of his being active on the phone or active on these prohibited dating sites. After the special conditions were imposed, she said she had the phone with her, apparently. She said, I've got the phone right here. It shows dates on which he posted pictures and liked people. Would you like to see it? And counsel declined, so that's substantial evidence. And the phone had photos, 9 of which, the nude photos of women, 9 of which were introduced into evidence. Those were on the phone on the date of the violations.
But does it indicate when they would have been sent to him?
Some of the pictures were dated in August. Mr. Coleman's.
And when did this condition, was it in September?
The conditions were imposed September 5th, 2018. The phone was discovered on September 18th. The pictures were still on the phone. Mr. Coleman testified. He did not testify that he never, that he knew that the pictures were there. He forgot to delete them. They were on the phone by accident after the conditions were imposed. He said that he couldn't stop people from sending them, and he had no idea why the phone had downloaded him or that.
So I just want to sort of put this together. So you don't know what the first or second crimes were or offenses were, but they could have been other instances, and I'm not lessening the seriousness of this at all, where he violated women by, in 3 different occasions, slapping their buttocks. That the third one, because within 10 years, would have amounted to a felony. Is that right?
That's right, Your
Assuming
Honor.
that that's what happened, because you don't know. But it could have been. That's why it's bumped up to a felony. Presumably it wasn't a felony, right?
That's right, Your Honor.
And then he while he was out, once he got out, after he got the 2 years, he refused to comply with the taking the urine, but then he did comply, and they let him continue. And then he had a phone, and he said he didn't have a phone. And for that, he was sentenced to almost 5 years. I mean, it just seems like there's got to be more than just this gentleman who lies about having a phone, or who, gives them a hard time about taking a urine. I mean, it just seems like he's not holding people up. There's no violence. There's no, it just seems like I'm kind of thinking, well, maybe they're overwhelmed in the parole office and they just don't want to deal with some guy who they, is just not going to cross all the T's and dot all the I's. Because it just seems like, that it seems like a lot for failing to talk about the phone. And I understand the potential that the phone carries, that what he can do, the fact that he can engage with women. But they're saying, we just want to know so we can check. Anyway.
That is what they were saying, and the point of the disclosure requirement is so that the parole officer can monitor use. But I would dispute that the characterization that Mr. Coleman got a 4-year time assessment simply for having a phone. It was not simply for having a phone. It was what he did with that phone that thwarted the supervision scheme and all of the key respects that we've been discussing in our brief. And I think what puts a point nicely on it is the
Yeah,
case.
not simply for having the phone. For having the phone where he had access, but that would be checked. I mean, if they gave him 2 years or whatever it was, when he got out, that would be checked. He would. I don't understand why he needs double the time he got originally to correct for having a phone where he accessed material that he should not have had, no question. But why isn't 2 years sufficient to correct that? Then he comes back out. You can go in for another 2 years if you can't seem to follow the rules. It just seems like double that time.
Well, the point that I was going to make, Your Honor, is that the case United States against Packingham that held that sex offenders have, or anyone has a right to use social media, talked about accessing LinkedIn and Twitter to discuss the issues of the day. It didn't contemplate a situation like Mr. Coleman's, which is not just having a phone that's not disclosed, but using it to go on dating websites under a fake name. Let's not minimize this conduct, and let's not stop it just
I don't believe I did minimize it. I think I spoke to the fact that that is clearly not what he's supposed to do. I'm saying that I don't, to give him 5 years or 4 years, where nothing is proven. I mean, anyway.
No,
Thank you. I understand. Thanks very much.
Thank you, Your Honor.
Okay.
To be clear, the special conditions, it's our position the special conditions imposed were unconstitutional, and this case is just like U.S. v. Eaglin, where a person under supervision who was on supervision for a sex offense could not access the internet or possess pornography.
In that case, there was a complete ban. There is no complete ban here. It's just, as I understand the condition, you have to get permission from the parole officer. Now, will the parole officer give permission to go on these, as you've characterized, these dating sites? No. But it's not a complete ban. He can access Twitter or other places, presumably.
Well, that's where Peckingham comes in, because Peckingham talks about accessing social media sites, which were the ones that he accessed, including Instagram, and those, and so there is a constitutional right, and none of.
Yeah, but they're talking about him using an alias to attract women who may not know that he's a level 2.
In Eaglin, it was dating sites as well. So in Eaglin, there were dating sites that he accessed, and that was the concern of the government, to prevent him from accessing dating sites and the pornographic material. And there they said that the special condition was not reasonably related, because, and in this case, it's the same, because Mr. Coleman did not use the internet at all for any of his sex offense, which was slapping a woman on the buttocks. So had the internet or accessing been that, then it could have been reasonably related.
Thank you. Thank you both. Board of Managers versus 3585 owner.
Good afternoon, Your Honors. Jared Paya for the appellant. May it please the court. This case concerns claims by a condominium board of managers against sponsor and other culpable parties for construction and design-related deficiencies. The lower court erred in multiple respects in granting the defendant's motion for summary judgment and dismissed 4 causes of action: fraud in the inducement, breach of fiduciary duty, breach of the bylaws, and also to set aside fraudulent conveyances. I'll start with the fraud and the inducement claim. First ground on which the lower court dismissed that claim was that it was supposedly barred by the Martin Act. As Your Honors will know, under assured guarantee and its progeny, allegations of affirmative misrepresentations as opposed to omissions in an offering plan are actionable common law fraud claims. Here, there are 3 primary allegations supported by evidence of misrepresentation.
Let's assume you're correct about that. Okay. But let's go on to the other grounds.
Okay, so in the next round was that the fraud claim was duplicative of the breach of contract claim. As this department held in the South Star, which is factually identical to this case, those claims are not duplicative. The offering plan serves a dual purpose. It's a part of the contract, but it's also a prospectus. It's a promotional tool that's used to...
But aren't the allegations based on the same conduct?
They're based on different conduct, and they derive from a different duty. The sponsor has a duty by soliciting sales of the units to be truthful in the offering plan. In fact, the sponsor and the sponsor's principals swear under oath in a certification in the offering plan that everything there is not only truthful and accurate, but that prospective purchasers can rely on those representations in deciding to enter into their purchase agreements in the first place. So it's different. It's a separate duty. The Court of Appeals and this very department has been clear that there can be allegations based on similar conduct, but if it relates to a different duty, the 2 causes of action are distinct, and that's the case here.
Were those statements in the offering plan, were they false representations of present fact?
This building, when the offering plan was distributed to unit owners, was already in construction. They concerned conditions that we, as far as we know, were already built. The certification, the offering plan, stated that the sponsor and its principals conducted due diligence in ensuring that these representations were true.
So these representations you're talking about, they were declarations of the intention to use certain materials, right? There were certain caveats that they had to use better materials or something else, but that was in the plan, right? That was in the very statement. So I'm trying to figure out why the fraud claim is different.
Well, the fraud claim is different. It's because it's based on the representations in the offering plan that unit owners received in advance of deciding to make their purchase, that they read, just like a prospectus with any security. The condominium unit is a security under New York State law, under the Martin Act. So unit owners would receive this document that would have various disclosures, various representations as to what they should expect in deciding to enter into their purchase agreements. They relied on those representations, then in deciding to make that purchase, to sign their purchase agreements. Then once they moved into the building, including these misrepresentations in common areas of the building that
I'm sorry, I think what my colleague was getting at, and you haven't, I don't think you've answered the question, is with respect to, for example, I think there were supposed to be Toto toilets or something like that. Isn't that part of the claim here? That in fact there were substitutions, that the right materials weren't used?
So
is that correct? Am I correct?
That's correct, Your Honor. So that.
Okay, so let me stop you there for 1 second. You also have to show reasonable reliance for fraud. Isn't all that subject to inspection?
It's not the misrepresentations that concern components of the building in common areas. So for example, the liquid applied roof membrane, that is a superior type of roof. Instead, an asphalt roof was installed, which was inferior.
But they're saying that that roof that was installed had a longer warranty period than the one that was in the document. So it said that they could put something in that was better. So arguably, that was better.
Well, Your Honor, I'd like to quote from our forensic engineer's report. And mind you, defendants didn't put forth any expert witness report or testimony or anything. And I'm quoting, "Conventional asphalt roofing was substituted for the higher quality liquid applied roofing over concrete topping slab." So just that example, our expert concluded the same thing for the Toto toilets, that they were far superior than the Kohler toilets that were installed.
So even though they were far superior, even though, for example, that roofing was far superior, it had a lower, by 10 years, I think it was, warranty.
That may be true, Your Honor, but that doesn't detract from the fact that one thing
But what you're
was
saying is that
represented in the offering
you're
thing. And
talking past the fact, an expert looking at it, versus them using what seems to be reasonable under the circumstances if they found a product that had a greater warranty.
just because it has a longer warranty doesn't make it a comparable substitute. And that's not coming from me, that's coming from our forensic engineer.
And then going back to the toilets, couldn't the prospective owners see that, in fact, they had Kohler toilets versus Toto toilets?
So, Your Honor, I mean, the opportunity to observe these toilets was right before the closing in a hastily put together pre-closing inspection. They didn't have the benefit of doing destructive testing and examining every crease and crevice of their unit. So unit owners didn't recognize this until after the fact, until their toilet started malfunctioning. They investigated and they saw that this was not the toilet that was promised. So, Your Honor, and in any event, I think reasonable reliance is something that a trier of fact should decide. I mean, we're having a debate right now as to whether this was reasonable or not. This is not something that should be decided on a summary judgment, especially without the benefit of any type of expert rebuttal evidence on the part of defendants. The motion court also dismissed the fraud claim against the sponsor's principals. I'm going to go back to the South Star case where this court held that by signing the certification in the offering plan, sponsors' principals can be personally liable for the representations in the offering plan. The breach of fiduciary duty claim was also dismissed on the ground that it was duplicative. These are totally separate claims. Breach of contract is based on a breach of the purchase agreement. Breach of fiduciary duty was against the sponsor-appointed board members based on conduct that they committed several years later while controlling the board.
And that conduct, isn't that subject to the business judgment rule?
It's not if it's in bad faith and in breach of its duty towards the condominium's unit owners. So, for example, the sponsor control board didn't perform any repairs or maintenance. They never held any meetings. Okay, they never pursued the sponsor for any of these issues. In fact, one of the sponsor-appointed board members in his testimony admitted that he didn't even know he was on the board. So, I mean, their duties were extremely derelict. And such bad faith is not protected by the business judgment rule.
Counsel, but isn't that claim also duplicative of the breach of contract claim? The breach of fiduciary duty, isn't it?
Your Honor, it's not duplicative. It's a totally separate claim. First of all, it's against different parties. Second of all, it concerns conduct that happened subsequent to all of the unit owners entering into their purchase agreements. It's based on the sponsor-appointed board members' service on the board and the shirking of their obligations as board members. There's nothing to do with unit owners entering into purchase agreements with the sponsor, so it wouldn't be duplicative. Finally, in terms of the lower court's dismissal of the breach of the bylaws claim, that one's clear. I think that there was a clear error. The bylaws say that the board's consent's required for any alterations to common elements. Here, the commercial unit owner installed an HVAC unit, affixed it to the exterior wall of the commercial unit, which is clearly a common element under the terms of the bylaws. So that claim should have survived. Lastly, I just want to point out that the claim to set aside fraudulent conveyances was improperly dismissed for two reasons. One, the claims of distributions to what are admittedly the entities owned and controlled by the sponsor's principals. There's no evidence whatsoever that those payments were to repay a loan. That's the claim that the defendants put forth. They submitted no documentary evidence whatsoever that there was any loan agreement. So there were tribal issues of fact with respect to that branch of the claim. The second branch of the claim was that the commercial units were conveyed without fair consideration to an entity owned and controlled by one of the sponsor's principals.
Thank you. There's a question.
I just want to go back to the breach of the bylaws, because what about section 7.9H? Couldn't the sponsor make interior and exterior alterations to the units without the board's consent?
Absolutely, but the alterations here weren't to the unit as that term is defined in the bylaws. They were to the exterior wall of the commercial unit. And under the terms of the bylaws, that is a common element. It's not part of the unit.
Thank you. You have some rebuttal.
Thank you.
Good afternoon.
Yes.
May it please the court. David Guys from Rifkin Radler for the respondents. I'd just like to start, oh, I'm sorry.
Well, I have a question. Does someone else have a question?
No, he thought so. Go ahead, go ahead.
Well, I have a question. I understand that the offering agreement specifically stated that the sponsors could substitute materials, but it says better quality. The plaintiff's expert indicated that the toilets flooded, there was ponding on the roof, the exterior, the door entry operator kept malfunctioning because there wasn't a vestibule as was indicated in the offering agreement. So the fact that the defendants didn't submit expert affidavit to refute anything that was inside the plaintiff's expert affidavit, isn't that a tribal issue of fact that should go to the jury?
It is not, and I'll explain why. First of all, it's not that there was no evidence that was submitted. The prima facie case was established by the evidence from Mr. Quaco, who was extensively questioned about his background in these matters, and he has an extensive background. He's done these before. So I think that, frankly, the expert affidavit wasn't necessary. Also, I would point out that the expert report that was cited by the appellant, it doesn't actually have any analysis as to whether the toilets are better or worse, or whether the roof is better or worse. All that it does is parrot the language in the complaint, and it's almost word for word that they are the inferior Toto toilets.
What about that roof? That the toilets, as my colleague had pointed out, you could tell whether you have a Toto or you have a Kohler, and maybe you could consider, question that. What about the roof, where there wouldn't have been a way for each individual to just not likely that they're going to go up and inspect the roof to see whether it met the terms?
I don't think that there's any evidence in the record to suggest that prospective purchasers couldn't go up and see the roof. I think that the purchase agreement
I guess what I'm saying is, if you go into an apartment, you can see whether it says Kohler or Toto. It's quite apparent. If you go up to a roof, unless you get your own inspector, you're not going to know what kind of component was put on the roof.
That's true. However,
so
the purchase agreement is clear.
The ability to inspect. Mm-hmm.
Well, they do.
They had the ability to inspect. I'm just saying what they would have learned from inspecting.
Well, they had the ability to have an inspector. I mean, there's nothing that says that they couldn't. In fact, the purchase agreement has language in which the purchasers are accepting what they're getting as is, and that they've had the opportunity to ascertain it. The Von Anken case which actually was initially cited by appellants, if you read that case, it's clear that the opportunity to ascertain the existence of a condition or not is what's really the issue. If this was a fraud,
I understand. I understand the opportunity. I'm just saying it's highly unlikely for that roof. Why don't you move on to the HVAC and the nuisance issue?
sure.
Appropriately.
I think that there's no evidence in the contemporaneous evidence that was submitted that there was ever any nuisance claim at the time that this was put in. And I think it's important to point out that when the HVAC was installed, there was full disclosure that it was being done. The board was fully aware. I agree that the language of the bylaws does not require consent, but notwithstanding that, my client, one of my clients, the sponsor, alerted the board to the work being done, provided the necessary paperwork, got the necessary approvals, and there's email traffic from the managing agent basically saying, let us know if we can do anything to help you out.
But why can't the appellant's claim damages for excessive noise, damage to the facade, based on a nuisance type cause of action, irrespective of whether or not you have the right to install the equipment without consent?
It could if there was evidence of that. This isn't a motion to dismiss, and I think that's an important point that the appellant's briefs really miss out on. It's treated as a motion to dismiss, but this is summary judgment. We made the prima facie case that there was no evidence of nuisance, that there was no evidence that that claim was real. And then there was nothing offered to rebut that. There's nothing in the record. There's no evidence that would support even raising an issue of material fact as to the nuisance. So it's not that they couldn't assert a nuisance claim, because they certainly could, regardless
So
of
you're saying
whether...
the affidavit in response to your motion is not sufficient?
I am. I'm saying it's a self-serving affidavit, doesn't raise any issues of material fact. And with respect to, it's not as if, for example, there's an affidavit in there that says there are X decibels of noise and it's causing a nuisance, or there's testimony or affidavits from any of the residents attesting to that. And it certainly wasn't an issue when they claimed that it was an issue back in 2016, because it's not in any of the board minutes. It's not in the June 30th letter that they sent. So I think it's pretty clear that the respondent made the prima facie case and there wasn't sufficient rebuttal. I would like to address on the omissions versus affirmative misrepresentations issue. The law is very clear that, and cases from this department are very clear that when the Martin Act requires a disclosure and that disclosure later isn't changed in response to changing circumstances, that is a cause of action that is preempted by the Martin Act. It's not a common law cause of action. That's exactly what's alleged here. With respect to the toilet and the roof and the vestibule, by the way, is something that anyone would have seen walking into the building, because there just was no vestibule. And it was disclosed in the Sixth Amendment to the offering plan in drawings that any layperson can read, that there would be no vestibule. There would not have been any disclosure but for the Martin Act requirements. So the need to modify those disclosures is also the product of the Martin Act requirements. And therefore, there are no, it's an omission rather than affirmative misrepresentation. And if I may, I know my time is up, just one minor...
Okay, get to it.
Okay, well, just one minor point. With respect to the fraudulent conveyances, there was documentary evidence in the record. There is documentary evidence in the record of what the loans were. They were used to save the construction. There is the complete accounting of those loans. It's contemporaneous accounting. It's not post-dated. It's not anything like that. There was no effort to conceal them. And they are clearly booked as the repayment of antecedent debt, and that debt consists of the loans and fees that we describe in our
Isn't there a
papers.
question, is there a question I should ask as to whether or not there was any relationship between the sponsor and, oh, I'm sorry.
There's no question, because everything is disclosed, Your Honor. The sponsor consisted of two members, which we refer to in our papers as and they're two separate entities. Those entities had principals. One of those principals was Mr. Quaco, who ultimately sat on the board and was the board's representative.
Yes, yes, I know who they were. I'm just, I was
So they
wondering.
were sort of members of members. Mr. Quaco separately owned a portion of an entity called Riverdale Avenue Holding, which is the entity that purchased.
The apartments or the commercial spaces or whichever they were.
Correct.
Right.
But that's not an entity that's affiliated with the sponsor in any way, shape, or form.
Okay. Thank you.
Thank you very much.
Your Honors, with respect to the fraudulent conveyances claims, I think I heard a concession by my adversary that these units were conveyed to what are insiders, okay? And the law is clear here. Even if there's questions of fact, whatever conveyance is made to an insider, it's, as a matter of law, it's not necessarily in good faith. It's not necessarily fair consideration because of the affiliation between the party conveying it and the party receiving it. In this case, the amount that the units were conveyed for was about $500,000 less than what those units were offered for at that time, okay? $500,000 less. At the minimum, there's a triable issue of fact as to whether that was fair consideration or not. That's something the lower court
issue of fact on the nuisance claim? Your adversary says you didn't put in any evidence to raise an issue of fact with respect to excessive noise as well as damage to the facade.
So, Your Honor, first of all, we believe that the defendants didn't even make a prima facie showing on that point. They didn't submit any evidence to meet their burden.
Well,
Nevertheless, in opposition, we submitted an affidavit by a unit owner who tested under oath that there's excessive noise coming from that unit. That's evidence. Under the CPLR 3213, that affidavit is admissible evidence to raise a triable issue of fact. Your Honor, I just want to make two other points. The offering plan, contrary to what my adversary said, the offering plan doesn't say that these units are being purchased as is, saying that they're being purchased pursuant to the representations in the offering plan. It's those very representations pursuant to which we claim there are misrepresentations between what was said and what was actually delivered. I don't have anything else further for Your Honors. Happy to answer any questions.
Thank you. Thank you both.
Thank you.
Rowald versus Dormitory Authority.
May it please the court, I'm Steve Araput from O'Dwyer and Bernstein for plaintiffs' appellants. It was error to refuse to enforce the settlement agreement because all of the defendants' arguments against the settlement were pretextual. Did
the settlement have all of the material terms?
Yes, all of them. Essentially, it's in a personal injury action like this, the essential term is the release of the parties and the amount, and that was provided.
Was the release complete?
The release was complete in the emails. It said, "This is to confirm settlement in the sum of $275,000. Please send release language and parties to be released."
So there was still some question, was there still some question about which parties were going to be released, and does that qualify as a material?
There was no question left open. an uncontested fact in this case that plaintiff had agreed to release any parties that the settling defendants requested. And that is, that fact was stated in plaintiff's moving affirmation, and defendants have never attempted to refute it. And by failing to refute it, it's admitted. It's a fact of this case. And that fact is reflected also in the, in the language of the email saying, send the parties to be released.
What about, counsel, what about the, this is personal injury action, obviously, so what about issues with respect to the workers' comp lien and the like?
As I've shown in my papers, although the plaintiff is required to get consent to settle the case at the amount that it is settling for, if the failure to do that only cuts against the plaintiff. And in this case, we knew that the final lien was $98,000, and against a $275,000 settlement,
So in other words,
the carrier would allow it.
you would be responsible for the entire lien, so it doesn't really affect defendant. Is that your point?
Essentially the entire lien. Of course, it's
yes.
reduced to $64,000 by the Kelly reduction. So yes, the entire comp lien would have been paid. And finally, with regards to the Medicare and Medicaid language that they say that the defendant's claim was left outstanding, plaintiff was not of age to receive Medicare, and he was not receiving either Medicare or Medicaid. And as defendants acknowledge, it's simple form language that is inserted into every settlement. It's not worked out in advance. The defendants just give the language and plaintiffs insert it. That's how it happens. It would radically change personal injury attorneys' abilities to settle cases in court or out of court if this kind of language was required. This is only coming up because defendants found out a day after they agreed to the settlement that the summary judgment motion had been decided, dismissing the case against them. The fact is, there was a completed settlement, and that should have been enforced.
Thank you.
Thank you.
Good afternoon. May it please the court, Joseph K. Strang for the respondents. I would begin by stating that I do not dispute that it is possible for a series of emails taken as a totality to form an enforceable stipulation of settlement sufficient to meet the requirements of CP law.
So in a personal injury action, what is the most important part of the settlement?
Judge, with respect, I don't think this is your average personal injury case. In a labor law action like this, where the cross claims are flying across each party's
You know, that argument, counsel, doesn't persuade me, and then I'll tell you why.
Yes, sir.
There are a lot of defendants in the case. Motions for summary judgment have been argued or submitted. Many of the defendants weren't willing to do anything except for your client. So it seems to me that your client was willing to settle the case irrespective of what occurred on summary judgment.
Judge, I understand the point of view that you're taking there. Notwithstanding, I dispute this. I think if you look at the chronology...
So then why didn't you take the same position as the other parties? Let's wait for the decision by the court before we settle this case, because obviously the value of the case goes up or down depending on what happens.
Both sides had risk here, and if that's the point you're making, I acknowledge that fully, sir. But notwithstanding, I think as you look at the viability of this appeal, you have to look at the four corners of the email chain. And as I reread the record in anticipation of today, I realized that both sides, in some manner, had relied on extrinsic matters outside of the four corners of those emails. And if you look solely at the emails, material terms are absent.
So tell us, which material terms?
Well, Your Honor, the one I would be most concerned with as the handling attorney here, My adversary states that, hey, you're the GC, you pay the settlement, you've got a complete defense to any claims by any residual parties, and that is true, but only with respect to claims for contribution. My concern here is that there's going to be a claim for contractual indemnity, which is not defeated under the GOL by the payment of a settlement. I can picture a circumstance where there's a 241 claim in the case, the owner and perhaps the construction manager are held statutorily liable, strictly liable, and then I've got to pay the case all over again because I'm going to be owing them an indemnity under the contractual claim.
Then I don't understand why you continue to go engage, why the other person continued to engage, knowing full well that everybody was saying, I'm not in this.
To add to that, to go so far as to say we are confirmed at a certain amount, right?
Well, Judge,
That's part of the email chain.
no question about that, and I don't deny the importance of how much to the overall context of a settlement, but I still contend, Your Honor, that there are material elements, perhaps unique to this labor law setting, where cross-claims and counterclaims and third-party claims are so intrinsic to these matters. I think those terms are material, and I look at the decision that, that Judge Leibovitz issued below. I think that this is a reasonable, thoughtful, detailed summary which covers many of the points that I'm now alluding to. He goes on for 7 pages, single space, about there can be material terms outside the question of how much. If Your Honors have any other questions, I'm glad to answer them for you. Otherwise, I'll yield back to my adversary. Thank you very much.
I would just like to point out that contractual indemnification concerns are exactly why it was within their power to tell plaintiff, release all the parties. Plaintiff had said that we would, and they don't dispute that we had said that we would. So they should have just said, release all the parties. In this case, would be settled.
Thank you.
Thank you.
Oh, I'm sorry.
Thank you.
Okay. Thank you. Thank you both. Barrett versus Russ.
Good afternoon, or good evening, as it were, Your Honors. My name is Lauren Price, and I represent petitioner in this matter, Marilyn Barrett. The case before you today is because Ms. Barrett appeals from a dismissal of her petition in Article 78 proceeding in the Supreme Court.
What can we do here when the 4-month time to file an appeal of the Article 78 is passed? What
Your
can we
Honor,
do?
this is a question that's at the heart of the matter. What Ms. Barrett was appealing from at the Supreme Court level, the only issue before this court is the appeal from the agency's decision not to reopen her termination proceeding. That was a timely made appeal within 4 months of that decision from the agency, and that's what she's appealing from today. She's not asking this court or the Supreme Court to overturn the underlying proceeding. She merely wants them to address whether the agency's decision not to reopen the hearing was arbitrary and capricious.
So what's the basis, I guess, to open it up at this point? I think you're arguing with respect to the batch procedures and that weren't followed, is that right?
I'm sorry.
What's the basis to open it up? Are you arguing that certain batch procedures weren't followed, or what? What's the basis for us to look at?
Your Honor, that is my argument at the lower court level, but here the only issue is that the Supreme Court dismissed this case when the appeal was timely made. I'm not asking this court to direct the agency to reopen the hearing. I want this case to go back to the Supreme Court for that court to hear and decide whether the non-reopening was arbitrary and capricious.
But can't we decide that now?
Certainly, Your Honor, but I think the record isn't complete yet without the agency answering the petition in the Article 78 proceeding. And as to the statute of limitations, to the first question, Ms. Barrett's appeal was made timely on a binding determination by the agency, which was the agency's decision not to reopen the hearing. The hearing officer duly considered the request. She read my request, she read the agency's opposition to it, and based on those papers, decided not to reopen. That was the arbitrary and capricious decision. Respondent and the lower court both inaccurately characterized her request as a request for reconsideration of the original termination decision. That was not the request. She did not seek for the agency to give her a different outcome. She sought to open the hearing and appear for the first time with new facts and information and defenses. And even if she had known about the outcome of the hearing the immediate day after it took place, and right at the time that the agency issued the original termination decision, appealing that decision would not have been a complete record. That's why she sought to reopen the hearing, so that she could appear, she could present the evidence and information that she did not have the opportunity to do at the original level. And that's why she made the request to reopen the hearing, not just to appeal from the termination decision that she didn't know about. And had the hearing officer did in fact consider those things when she made the decision not to reopen. That's the denial that we're appealing today. And there's no, just to note, to further clarify the statute of limitations issues, there is no statute of limitations, there's no timeline for making a request to reopen. And the agency in their own papers in this proceeding cited a case where they made a request to reopen a hearing some 8 or 10 months after a decision had already been issued. There's precedent in their own actions, and as part of the Blatch procedures that a case can be reopened by a tenant in a case. Even if the tenant were out of possession of the apartment, the case could still be reopened, and there's no timeline in any of the agency's procedures. And I'll reserve the rest of my time if the court has no further questions.
Okay, thank you.
May it please the court, Andrew Lupin for the New York City Housing Authority.
Ruben, what was the final determination here? Was it the June 10th decision to terminate her tenancy, or was it when the officer decided not to reopen the matter?
The final determination is the Housing Authority's determination of status, which approved the hearing officer's decision.
But what would have happened then had the hearing officer agreed to reopen the matter? Then the agency would have taken a fresh look at this, correct?
Well, there's no procedural basis for the hearing officer to have agreed
So that goes back to the issue I raised, that there's, I think it's the batch procedures. I think that's the claim that weren't followed. Presumably you're arguing that was not a basis to open it up, correct?
The Housing Authority's mental competency procedures, which were approved pursuant to the settlement of the Blatch case in federal court, permit tenants to apply to reopen a hearing in very limited circumstances. And those circumstances are if they can show that they were mentally incompetent at the time of the hearing, and if they were not represented by a GAL. In this case, she was assisted by a GAL at the hearing, so therefore there is no procedural basis for the Housing Authority to reopen the hearing. What the lower court recognized was that appellant was attempting to circumvent the statute of limitations by requesting—
Yet what I'm hearing from your adversary, that's not what she's attempting just now. She concedes that there is an issue with statute of limitations, but it's the renewal, it's the reopening.
But there's no basis to reopen a hearing. You can't reset this statute of limitations by just sending a letter to the hearing officer and asking for a new hearing. If that were the case, that would eviscerate the statute of limitations. If any litigant could just direct correspondence to the agency asking for a new hearing after the time to file an Article 78 has expired, then there would be no more statute of limitations. The parties would just send new letters.
What about, as counsel says, if she wanted to raise, I mean, you say with respect to Blatch that she had a GAL, she did. Counsel says, well, what if the GAL was ineffective?
Then she absolutely had the opportunity to raise those arguments in a timely filed Article 78 proceeding.
But if there's never any, with regard to, but there's no limit as to Blatch, right? Those can be raised at any time.
Only if you—
And so it would go directly to one of the factors of Blatch, right?
No, that's not what the procedures say. The procedures say you can only request a new hearing if you did not have a GAL.
Not if the GAL may have been ineffective.
No, there's nothing in the Blatch procedures that say you are entitled to request a new hearing based on your belief that the GAL was ineffective. The two cases that appellant cites in support of that position are Russo and Latoni. Both of those were timely filed Article 78 proceedings. They were filed within 4 months of the Housing Authority's final and binding determination. The Blatch procedures do not permit tenants to just willy-nilly request new hearings if they did not like the performance of their GAL.
Counsel, let's assume for argument's sake only that in fact she would have met the procedures under that settlement, under the Blatch procedures. Would that be then a basis for her to reopen the hearing, irrespective of the issue with respect to the statute of limitations?
I'm sorry, I don't understand.
In other words, even if the statute of limitations had expired and she met the conditions later on for reopening the hearing, did the Housing Authority have the right under those circumstances to open the hearing based on the settlement?
If she were not assisted by a GAL and she could show that she was mentally incompetent, and it's her burden to show that she was mentally incompetent at the time of the hearing but not assisted by a GAL, then she could apply pursuant to the Blatch procedures for a new hearing. And there is the Blatch procedures explain the process by which the hearing officer would evaluate that request. And first, the tenant has to satisfy their burden, and the Housing Authority could show that she actually was mentally competent at the time of the hearing or that it performed a GAL evaluation. However, the Blatch procedures are very clear that this is only limited to tenants that were not assisted by a GAL at the time. And if the parties that negotiated the Blatch settlement had intended for there to be a procedure whereby a tenant could request to reopen a hearing when they were assisted by a GAL at the hearing, then the procedures would say that, and the settlement would have included that language.
Counsel, are the Blatch procedures the only way that a tenant could ask the agency to reconsider?
There is nothing in the termination of tenancy procedures that permits a tenant to seek reconsideration or request a re-argument or anything like that. The determination of status is the final and binding determination, and the Housing Authority is entitled to finality after it goes through the administrative termination process.
Thank you.
Thank you, Your Honor.
Your Honors, to address a few points that my adversary made, this was not an attempt to reset the statute of limitations because she wasn't attempting to re-litigate the termination itself. She was attempting to open the hearing and appear.
But okay, so address your adversary's point that the procedures don't apply in the circumstances of your client's case because she was represented by a GAL.
Your Honor, the process of reopening a hearing is not exclusive to the Blatch settlement and the procedures from the Blatch settlement. This is something that, as I mentioned, and the authorities cited in their own papers, they do also. To reopen a hearing is not strictly a procedure under Blatch. Her request to reopen was very much supported by Blatch, the intention and the whole grounds of the Blatch settlement, so that people are competently represented in a hearing, tenants who are disabled.
Well, within maybe the spirit, but didn't quite meet the requirements because she was represented maybe by an ineffective GAL, correct?
That's correct, Your Honor, but my point is that there's nothing in NYCHA's termination procedures or anything in their procedures that has a time limit on a request to reopen a hearing. The agency uses this procedure themselves. A request to reopen is not strictly under the Blatch procedures. It's a procedure in their administrative process that a hearing can be reopened.
What section would that be?
It's not anywhere enumerated here. And if the agency could point to some timeline that says, a reopening request can be made in a year or 6 months or anything else, then we wouldn't have anything to argue about today. But there is no timeline anywhere in their procedures. And they make such requests, months and years after hearings themselves.
So, Counsel, you're saying that a person could request to reopen outside of the Blatch criteria?
Yes, Your Honor.
And where do you get that from? Is that the no section part that you just said?
It's not written down somewhere in their procedures. It is just is done. They consider, and here the hearing officer considered the request.
I thought I asked that of your opposing counsel, and the response was that the Blatch procedure was the only way. So you're disagreeing with that?
I disagree, and they cited a case themselves that where that procedure was done. It can be done and is done by the authority.
Okay, thank you very much. Thank you both.
Thank you, Your Honors.